Judicial from 31st now both states cannot come before. How can I order for now register judicial na kaate.
Mentioning page wise, this one, page 1, the number 1 to 10, page 2, the number 11 to 16, this one. This one.
ಏನಕ್ಕೆ we'll see.
Page 2, page 1, the number 6 to 7, page 2, the number 8 to 18, page 3, the number 19 to 28.
2 weeks kotre enen ole they are already on the vacation. 2 weeks kotre vacation ne baruttalla avare. Weeks time is granted request of counsel for petitioner. Will is this matter on 8/4.
Page 4, the number 29 to 43.
Why? Request of counsel 8/4.
Page 5, the number 44 to 52.
ಏನಿದು? Then why adjournment? 8-4. 7-4. If you have any difficulty on 8, 7-4. ಏನ್ ಮಾಡಕ್ಕೆ? ಆಲ್ರೆಡಿ ಒಬ್ಬರ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಲೆಟ್ ಅಸ್ ಸಿ.
Cases number 53 to 65.
Memo filed. Memo registered under the memo. Dismissed as done with liberty as paid for.
Case number 66 to 68. 63.
ಹೋದ್ಸತಿನೂ ಕೊಟ್ಟಿದ್ಯಲ್ಲ ಅವ್ರು. Hmm? 8-4.
This one, order first time matter, serial number 1, RP Deshpande.
HGP to take notice and file objection. Seal is this matter on 8-4.
Serial number 2, Supra
Same order.
3, Abdul Ahmed.
Same order.
Number 4, Arson Swami.
8-4.
Order serial number 5, SP Devaraj.
Of subjections to be complete in a week's time. Release this matter on 11-4.
Number 6, SPP.
Same order.
Number 7,
Same order. You have to comply of subjections. I am granting week's time and releasing out on 11-4.
Number 8, Nasir Ali.
Same order.
9, Chandrasekhar K.
Same order.
10, Vasant Raj.
Same order. You will have to cure the of subjection, sir. Please cure it. There are other matters on Tuesday. It has come up for the first time before this court. Hundreds of matters are posted every day. Yes, do it, 11-4. Of subjections cure ಮಾಡೋಗ್ರಿ ಬರ್ಲಿ ಅದು ನೋಟಿಸ್ ಕೊಡ್ತೀನಿ ಅವ್ರಿಗೆ. ನೀವ್ ಯಾಕಿರ್ಬೇಕು ಅದಕ್ಕೆ? Of subjections cure ಮಾಡಿ 11th ಬರುತ್ತೆ. ತಾವ್ ಹೇಳೋದೇ ನಿಮ್ಗೆ ಅರ್ಥ ಆಗಲ್ವಾ? ನೀವು ಮೊದ್ಲು ಆಫ್ ಸಬ್ಜೆಕ್ಷನ್ಸ್ ಕ್ಯೂರ್ ಮಾಡೋದ್ ಬರ್ಲಿ. Yes. 11-4. 11-4. 11-4. ಏನಿದು? ಆಯ್ತು, ಏನದ್ ನೋಡೋಣ. Issue notice to the respondent. Release this matter on 18-4. ಅದು ಏನದು ಕೊರಿಟ್? Yes, why do you want to quash? It's only taking cognizance and issuing summons. Why it should be quashed? ಅದೆಲ್ಲ ಅಲ್ಲಿ ಹೋಗಿ ಹೇಳ್ಕೊಳ್ಳಿ, ಡಿಸ್ಚಾರ್ಜ್ಗೆ ಹಾಕೊಳ್ಳಿ. 482 ಯಾಕೆ? ಒಂದ್ ವಾರ ಎಲ್ಲ ಕೊಡೋದಿಲ್ಲ ಇದೆಲ್ಲ. ಸುಮ್ನೆ ಅಲ್ಲಿ ನೀವು ಅಲ್ಲಿ ಹೋಗಿ ಅಪಿಯರ್ ಆಗ್ರಿ ಅಂತಂದ್ರೆ ಅದಿಲ್ಲ. ಐ ಅಪಿಯರ್ಡ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್. ಅಪಿಯರ್ ಆಗಿ ಆಮೇಲೆ ಏನ್ ಆರ್ಡರ್ ಮಾಡ್ತಾರೋ ಮಾಡ್ಲಿ ಅವರು. ಇಶ್ಯೂ ಸಮನ್ಸ್ ನ ನೀವ್ಯಾಕೆ ಚಾಲೆಂಜ್ ಮಾಡ್ತೀರಿ? ಆಫ್ಟರ್ ಆಲ್ ಸಮನ್ಸ್ ಹ್ಯಾವ್ ಬೀನ್ ಇಶ್ಯೂಡ್. ಗೋ ದೇರ್, ಸೇ ವಾಟ್ ಎವರ್ ಯು ವಾಂಟ್.
Yeah, please.
Vidhyana, 2:30.
Oh.
Summons issue ಮಾಡಿದ್ರೆ 482 ಹಾಕಿದ್ರೆ ಏನ್ರಿ? Pass over. Pass over. Memo filed, memo reads as under, the memo petition is dismissed as withdrawn. HCGP to take notice and file objections, 8-4, serial number 3 to 5. C.H. Sanmantraya. Pass over.
Serial number 4, first time.
HCGP to take notice and file objections.
Investigation 3774.
ಅಲ್ಲ ಇವಾಗ 8-4 ಕೊಟ್ಟಿದ್ದೀನಿ, ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ಲಿ, ಅದಿದ್ರೆ ಅದು ಅವತ್ತು ತಗೊಳ್ಳೋಣ. ಯಾವತ್ತಿಗಿದೆ ಅದು?
ಈಗ ಡೇಟ್ ಇಲ್ಲ, ಇದು ಕನೆಕ್ಟೆಡ್ ಸೇಮ್ ಟೈಮ್.
ಕನೆಕ್ಟೆಡ್ ಇದ್ರೆ ಅದು ಬಂದಾಗ ನೋಡೋಣ ಅಷ್ಟೇ. ಇದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿ, ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರ್ತದೆ. ಬರ್ಲಿ ಇದು 8-4. ಸೆಕೆಂಡ್ ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಮಾತ್ರ 11-4. ಹೇಳಿ ಹೇಳಿ. Yes.
All of the family members, including Ramya Gowda, by that time, the Iptari Gowda was lying with the bone blood. After noticing the same thing, he was shifted to hospital in an ambulance. That he was the petitioner himself shifted his senior anchor in the ambulance. He was provided first aid. Then at the advice of the doctor, he was shifted to Bangalore Hospital, Limas Hospital for further treatment. Where he was declared
Dead.
So, at that incident, the Ramya Gowda lodged a complaint against an unknown person.
Yes, please.
And later, the FIR was issued for the early defense 302 for the person. Later, subsequent development 302 against the very petitioner.
Yes.
The allegation, but in the FIR, the name of the petitioner not like the petitioner's father himself not a complaint against anyone. Intention or motive or anything to commit a murder. So, by mistake,
Where is the remand application?
the petitioner indicated in the allegation.
Where is the remand application?
But I read the application is finds that it is number 21.
No, that is the application seeking requisition. You are not filed. Court will be mistaken for everything. Shivaswamy avare. Court will be mistaken for anything and everything. This is the type of petitions that we have. See, if an unknown person against whom the FIR is filed And later on, if the police were to find a particular person who is responsible for the act, what is the bare minimum requirement that is to be filed along with the petition? Remand application, they would have stated, no? You have the copy of the remand application with you. What made the petitioner to, what made the police to take the petitioner into custody? Please. Kindly read. You read it by.
The first page, the reflect very same complaint. And the second page, Antara Jalaka, every entry, first Antara, the Maka, the clear ಆರೋಪಿಗಳ ಪ್ರತಿಗಾಗಿ ಅವರ ಮೇಲೆ ಪಿಸಿ ಅವರು ಬಾತ್ಮೀಕರಣ ಮಾಹಿತಿ ನೀಡಿದ್ದಾರೆ ಎರಡರಲ್ಲೂ ವಶಕ್ಕೆ ಪಡೆದ ಸಂದರ್ಭದಲ್ಲಿ 7 ಪಿಸಿ application, the reason why
File copy of the current counsel for the petitioner to file remand application. In the meantime, Kannada HGP to file objections to the main petition. Release this matter. ಯಾವತ್ತು ಬೇಕು? And the second is the last working day. 21/4. ಅವತ್ತೇ ಒಂದೇ ದಿನ ಇರೋದು. Yes. Pass over. Suyog. Pradeep. Farouk. Chandra Kumar Gowda. Jagdisha. ಹೇಳಿ. Yes. Yes, please. Yes. Already ಡಕಾಯಿತರ ಹೆಸರೆಲ್ಲ ಯಾರಿಗಾರು ಗೊತ್ತಿರುತ್ತಾ? No, please tell me, if somebody comes to rob me, will I ask them their details and then tell them you rob me then? TIP, if it is not conducted, it's a matter for the trial. Take advantage of it during the trial. Admittedly, CW 4 and 5, who are the inmates in the house, you have shown the knife to them when they got up and prevented the act, and they have identified you in the police station. There is the question of TIP then. That you take it advantage there. What is the recovery? What is the recovery? Antecedents. ಮತ್ತೇನ್ ಮಾಡಕ್ ಬರುತ್ತೆ? ಬರ್ಕೊಳ್ಳಿ. Heard Sri Jagadisha H and learned HGP. Present petition is filed on section 439 CRPC with the following prayer. First, next para. Brief facts of the case are as under. Yes, ma'am. After hearing Sri Jagadisha H for some time, he files a memo. Memo reads as under. In view of the memo, petition is dismissed as not pressed with liberty as prayed for. Pass over. Girish.
Appearing for petitioner, my lord. Kindly pass over, my lord.
Pass over. Mohammed Pasha. Pass over. Yes, pass over. Pass over. ಏನದು ಯಾಕೆ ಸರ್ವಿಸ್ ಪೆಟಿಷನರ್ ಯಾರಿಗೆ ಪಾಸ್ ಓವರ್? ಯಾರು ಬರ್ತಾರೆ? ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಅಂತಲೇ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿರೋದು. ಪಾಸ್ ಓವರ್. ಎಸ್ ಹೇಳಿ. ಎಸ್ ಪ್ಲೀಸ್. What is the quantity of the NDPS seized? All right. Heard. Sri But Ramachandra Ganapati and learned HGP. Present petition is filed on section 439 CRPC with the following prayer. First, a brief facts of the case are as under. a report came to be filed by Sri Rakshit A.K., son of Kagegowda, a police officer, to Chikmagalur police station. It was registered in crime number 62 of 2021 for the following offences. 20B, so and so. Page number 12. In the report, it is contended that when complainant was in the police station on 26/8/2021 at about 1 p.m., he received a credible information that somebody is transporting ganja in a car bearing number KA03 MQ 519 Pusta. Accordingly, he formed a team for the intended raid and secured the presence of the two independent master witnesses. Pusta. He has also secured the presence of a guested officer. Pusta. The entire raid team was waiting for the car. Pusta. On ಯಾವ ರೋಡ್ ಅದು? ಚಿಕ್ಕಮಗಳೂರು ಬೇಲೂರು ರೋಡ್. ಚಿಕ್ಕಮಗಳೂರು ಬೇಲೂರು ರೋಡ್ in front of B Hive. B Hive. ಜೇನುಗೂಡು ಅಂತ. B Hive homestay. As per the credible information, first at about 3:05, at about 3:25 p.m., a car bearing number KA03 MQ 519 came there. First, it was intercepted by the raid party. First, immediately the inmates of the car tried to ran away. First, however, raid party were able to secure, were able to take them to their custody. First, in the presence of the guested officer, the car was searched by the head of the raid party. First, in the backside of the car, Ricky, the raid party was able to find four white colored plastic covers tied. First, on opening the said bags, the raid party was able to find ganja in it. They seized ganja from all the four bags, totally weighed 101 kg 20 grams. First, sample was taken and admittedly the inmates of the car did not possess any license or permit for transportation of the ganja, hence it was treated as illegal ganja and the persons were arrested. First, based on the report lodged by the head of the raid party, Chikmagalur police registered the case and investigated the matter. First, the investigation agency has also filed charge sheet against the petitioner and others. First, in the meantime, the attempt made by the petitioner seeking grant of bail was turned down by the learned Principal District and Session Judge Chikmagaluru in crime number 62 of 2021 by order dated 17 September 2021. Thereafter, petitioner is before this court. That counsel for the petitioner, Shri But vehemently reiterating the bail grounds, vehemently contended that the petitioner he is no way connected with the alleged crime. First, he further contended that petitioner is only the driver of the car and he did not know what was inside the tied plastic bags, and therefore he cannot be held responsible for the illegal transport of ganja and sought for grant of bail. First, he also emphasized that the charge sheet is now filed, the continuation of the petitioner in judicial custody is no longer warranted. First, he further contended that petitioner is having a small child, young child, and therefore sought for grant of bail. First, per contra, learned HCP opposes, per contra, next para, opposes the bail petition on the ground that the seized ganja is to the tune of 101 kgs. First, how exactly the petitioner is also connected to the incident is already investigated by the police, and the material in the form of charge sheet clearly indicate that the petitioner is also involved in the incident and there's a direct nexus between the incident and the petitioner. First, he further contended, having regard to the provisions of section 37 of the NDPS Act, the petitioner has to make out a case, that reasonable case, that he is not guilty of the offence alleged against him, and no such case is made out by the petitioner and thus sought for rejection of the bail petition. First, next para. In the light of the argument put forth on behalf of the parties, this court perused the material on record meticulously. First, admittedly, no further details are forthcoming from the petition governments or from the charge sheet materials that the car was in fact hired by the other inmates of the car and petitioner was only a driver. First, on the contrary, material on record could also prima facie establish that petitioner was also involved in the incident. First, at this stage, this court cannot hold a mini trial to find out the fact that the petitioner was only a driver and he was not at all connected with the incident. First, the material on record also indicate that the seized ganja is to the tune of 101 kg 20 grams, and therefore the commercial quantity of ganja having been seized, the embargo found in section 37 of the NDPS Act in respect of the powers of this court under section 439 CRPC is very much applicable in the case on hand. First, as such, this court is of the considered opinion that the grounds urged in the petition are not sufficient enough to form a prima facie opinion that the petitioner is not responsible for the alleged crime. Accordingly, following order is passed. Bail petition rejected. Pass over. Yes, please. To the tune of 12.5 lakhs. Yes. Yes.
2018 to 2021. What is heard, one, April, 41 24, 2021. There was no separation. All these months they kept quiet. No one there visiting my residence and trying to arrest.
Yes, Mr. What do you want? 10/4/2021, almost a year. What are you doing? She has appeared. She has appeared before you. You have inquired her. No, she has inquired her. Let her go and join the investigation if need be. Yes, heard. Both sides. First, petitioner under section 438 CRPC with the following prayer. First, next, brief facts of the case are as under. A complaint came to be filed by
Complaint is in the
Om Prakash, son of Shivanand. Om Prakash, son of Shivanand. Where is the complaint?
along with the memo I placed it. Along with the memo.
To SG Palya Police. SG Palya Police. Which on. Where is the date for this complaint? On 5/4/2021. 5/4/2021. First, based on the said complaint, Suddagunte Palya Police registered a case in time number 85 of 2021 for the offence punishable under section 408 and 420 IPC. First, after registering the case, a notice under section 41A of the CRPC came to be issued against the petitioner by the concerned police dated 10/4/2021. First, next para. It is contended that as per the notice dated 10/4/2021, petitioner appeared before the police and she has already given her statement and police have inquired necessary details from the petitioner. Despite the same, there was no final report filed in respect of the said petition, said complaint, and police are unnecessarily harassing the petitioner. Petitioner approached the jurisdictional court for grant of anticipatory bail in semis number 11086 of 2021. First, London District Judge by order dated 21st December 2021 turned down the request made by the petitioner, and thereafter petitioner is before this court. First, in the complaint filed by Sri Om Prakash, it is contended that the petitioner is involved in misappropriating the amount of the company of SS Polymers to the tune of rupees 12,50,000. First, Land Counsel for the petitioner vehemently contended that earlier to filing of the petition by the complainant herein, she herself has lodged a complaint against the accountant, against the manager of SS Polymers on 30/3/2021, and as a counterblast, present complaint came to be filed by Om Prakash and sought for grant of anticipatory bail. He further contended that the investigation agency did not deem it fit to arrest the petitioner based on the averments found in the complaint, and therefore issued a notice under section 41A of the CRPC on 10/4/2021, directing the petitioner to appear before the investigation agency for the purpose of investigation on 12/4/2021. First, the Land Counsel further submits that the petitioner complied the said direction of the police, and thereafter there is no progress in the case, and all of a sudden police are trying to arrest the petitioner, which made him to approach the district court. First, he further contended that learned district judge did not properly appreciate the matter on record and rejected the prayer, and therefore sought for the protection from this court. First, next para. Per contra, learned HGP opposes the bail petition, contending that even after service of the notice on 41A of the CRPC, petitioner there is a need for the custodial immunization of the petitioner in respect of the documents produced by her, and therefore anticipatory bail is to be rejected. First, taking note of these aspects of the matter, this court perused the matter on record. First, admittedly, a complaint came to be filed by the petitioner against the manager of SS Polymers on 30/3/2021. Thereafter, as a counterblast, on 5/4/2021, SS Polymers lodged a complaint with Sudgunte Palya Police First up, petitioner lodged the complaint with Michael Layout Police. First up, when the matter stood thus, a notice came to be issued against the petitioner by the Suduguntepalle Police under Section 41A CRPC, directing the petitioner to appear before the investigation agency on 12/4/2021. First up, Netpara. As per the notice, petitioner appeared and produced certain documents before the investigation agency. First up, however, the police, Suduguntepalle Police, have not filed any charge sheet against the petitioner herein in respect of the complaint lodged by Shri Om Prakash. First, be it what it may, the apprehension now expressed by the petitioner appears to be real apprehension, and therefore, petitioner being a lady is entitled to be protected by an order of grant of anticipatory bail. Accordingly, following order is passed. First, petition allowed petitioner to join the investigation by appearing before the investigation agency on 11/4/2022 at 10 a.m. First, in the event of any custodial investigation being necessary, the investigation officer is at liberty to take her to custody and complete the custodial investigation on the same day before 4 p.m. First, thereafter, petitioner be enlarged on bail by taking a bond in a sum of rupees 50,000 with one surety for the like sum. First, petitioner shall cooperate with the investigation agency, and in that regard, she shall mark her attendance before the investigation agency every third Sunday between 10 a.m. to 2 p.m. till the final report is filed. First, petitioner shall attend the court regularly. Petitioner shall not hamper the prosecution witnesses nor hamper the investigation process directly or indirectly. First, petitioner shall not leave the jurisdiction of Bangalore district without their permission. Violation of any one of the conditions would entitle the prosecution to seek for cancellation of the bail. Ordered accordingly. Nim role eno?
From the fifth day number 1 to 3, 5 to 15.
Nim role eno? You are accused number 1. Accused number 1, the persons who have been granted bail.
Number 1 to 3, 5 to 15, not the object for the sector object, not the fees of 38,000. Then evidence is only not one was taken to only.
Oh, since how long you are in custody? 3.5 years. Yen ಮಾಡ್ತಿದ್ರು ಮತ್ತೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ? What's happening? 3 years in custody. What's happening in the trial? ಅದನ್ನ ನೀವು ಹೇಳ್ಬೇಕಲ್ಲ. ಟ್ರಯಲ್ could be expedited ಅಂತ. ಆಯ್ತು ನೋಡೋಣ, 3 ವರ್ಷದಿಂದ ನೀವು ಇದ್ರೆ ಇದ್ದಕ್ಕಿದ್ದಂಗೆ ಏನ್ ಅವಸರ ಅಂತ ಬೇಲ್ಗೆ. ಅದ್ಯಾತ ಕಾಯ್ಕೊಂಡು ಕೂತ್ಕೋತಾರ್ರಿ? ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದ್ದಾಗ ಬೇಗ ಮುಗಿಬೇಕಲ್ಲ ಕೇಸು. Now what is the stage of trial? 3 ವರ್ಷದಿಂದ if somebody is in custody, how can it be? Yes, what is happening? SC number ಎಷ್ಟು? 89 of 2020. ಅಲ್ಲಿ ನೋಡಿ ಏನಾಗಿದೆ 89 of 2020 ಲಾಸ್ಟ್ ಡೇಟ್ ಏನ್ ಸ್ಟೇಜ್ ಇದೆ? ಚಾರ್ಜರ್ ಫ್ರೇಮ್ ಆಗಿದೆ ಇದು. SC number 89 of 2020 on the file of CCH 59. I'll direct that the matter to be over in 1 month. 3 ವರ್ಷದಿಂದ ಆಗ್ದಲ್ನೇ ಇದ್ದಿದ್ದು ಇವಾಗ ಎಲ್ಲಿದ್ದಾರೆ ಹೇಳಿ? Correct. The question is, ಅದನ್ನ ನೋಡಿದವ್ರು ಯಾರು ಇಲ್ಲ, ಎತ್ತಾಕೊಂಡೋಗಿದ್ದಕ್ಕಿದ್ದಾರೆ. Let us see what happened. ಅದನ್ನ ನೋಡಿದ್ರೆ ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟೇಟ್ಮೆಂಟ್. ಅದರಲ್ಲೆಲ್ಲ ಬೇಲ್ ಆಗಿದೆ 11 ಕೇಸಸ್ ಅಲ್ಲಿ. ಏನ್ ಕೇಸಸ್ ಡೀಟೇಲ್ಸ್ ಅದು? ವೇರ್ ಆರ್ ದೋಸ್ ಡೀಟೇಲ್ಸ್? No, where you have given those details? No, instructions are different, but where is the question of details? In petition ಅಲ್ಲಿ ಹೇಳ್ಬೇಕಲ್ಲ, ಏನು ಹೇಳಿಲ್ಲ. Yes, heard Sri Prasanna Kumar and learned HCP. The order sheet ಅಲ್ಲಿ objections filed by the prosecution taken on record ಅಂತ close ಮಾಡ್ಕೊಳ್ಳಿ. The present petition is under section 439 CRPC with the following prayer. First, three facts of the case are as under. A complaint came to be lodged by Sanjay, son of Hanmanta, based on which Begur police initially registered a case under section 363 IPC. First, in crime number 146 of 2019. First, the complaint governments reveal that the complainant is working as a driver, and on 30/8/2019, his relative Sunila had visited his house in Maiko layout at 7 p.m. After having a conversation with him, he left his house around 8:30 p.m. And at that juncture, when he was when he was about to leave his house, near the gate, present petitioner and others came there, and they took him along with them. First, complainant felt that they may be the friends of his relative. First, however, after a while, he heard huge hue and cry. First, on seeing him, on being anxious, he came out and saw that the petitioner and others were assaulting his relative Sunila. First, Sunila was raising alarm for the help. Immediately, he rushed to the spot. By then, the petitioner and others had abducted the Sunila to some unknown place. First, based on the said complaint, police registered the case and investigated the matter. First, during the investigation, the investigation agency is able to find the dead body of Sunila, and later on invoked section 302 IPC in the matter. First, petitioner was apprehended, and so also other accused persons. First, petitioner approached the district court in SC number 89/2020 for the purpose of grant of bail under section 439 CRPC. First, learned district judge, after hearing the parties by order dated 4th June 2021, rejected the bail application. First, thereafter, petitioner is before this court. First, land counsel for the petitioner, Sri Prasanna Kumar, reiterating the bail grounds, contended that the co-accused persons who are similarly placed with the allegations that of the petitioner have been granted bail by this court, and therefore, without further discussion on the merits of the matter, the petitioner is entitled to be enlarged on bail. First, further, he contended that entire case is based on circumstantial evidence, and therefore the petitioner is entitled for an order of grant of bail. First, he also pointed out that the accused is in custody since Yavatu September 2019, and trial has not progressed, and therefore on that ground also is entitled for an order of bail. Full stop. Full stop. He further contended that since the charge sheet is filed, continuation of the accused petitioner judicial custody is no longer warranted. Full stop. Per contra, learned HCP opposes the bail petition on the ground that ground of parity is not available to the present petitioner, inasmuch as present petitioner is involved in 11 cases, and he has given the details about the 11 cases. Full stop. On perusal of the objection statement, full stop. He further contended that for the abduction of the Sunila, there are eyewitnesses including the complainant, and so far as the murder is concerned, the case is based on the circumstantial evidence, and therefore the argument put forth on behalf of the petitioner cannot be countenanced in law and sought for dismissal of the bail petition. Perusal in view of the rival contentions, this court perused the material on record meticulously. First, admittedly, the petitioner is involved in 11 criminal cases, including the cases for the offense attempt to murder, abduction, and also murder and dacoity. First, in other words, petitioner is having a criminal history. First, further, the abduction of the deceased was seen by the complainant, and in the complaint itself, the name of the present petitioner is found. First, further, the grant of bail to the co-accused persons would not act as a parity in the case on hand in of the specific court act alleged against the petitioner herein, and also taking note of the antecedents of the petitioner herein. First, therefore, without expressing further opinion on the merits of the matter by holding a mini trial, this court is of the considered opinion that petitioner has not made out any good grounds to grant the bail by resorting to the special powers vested in this court under section 439 CRPs. Accordingly, petition is dismissed. First, however, taking note of the fact that the petitioner is in custody from September 2019, trial court is directed to expedite the trial and conclude the same on or before 30th September 2022. ಇನ್ನು ಮುಂಚೆ ಬೇಕು ಅಂದ್ರೆ ಸ್ವಲ್ಪ ಮುಂಚೆ ಆಗ್ತೀನಿ, ನೀವು ಕೋಆಪರೇಟ್ ಮಾಡೋದಾದ್ರೆ 31st August ಬರಲಿ. ಸುಮ್ಮನೆ ಇಟ್ಕೊಂಡು ಕಸ್ಟಡಿಯಲ್ಲಿ ಇಟ್ಕೊಂಡಿರೋ ಕೇಸಸ್ನೆಲ್ಲ ಏನ್ ಮಾಡ್ತಾರೆ ಇವರು? ವಾಟ್ ಆರ್ ದೇ ಡೂಯಿಂಗ್ ಮಿಸ್ಟರ್? ಎವ್ರಿ ಮಂತ್ ವಿ ಆರ್ ಸಪೋಸ್ ಟು ಗಿವ್ ದಿ ಕಸ್ಟಡಿ ಸ್ಟೇಟ್ಮೆಂಟ್. ನೀವು ಅದನ್ನ ಬರೆಯೋದಿಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ. ಯಾತಕ್ಕೆ ಅವನ್ನ ಉಳಿಸ್ಕೊಂಡಿದ್ದೀರಿ? ತೀರ್ಮಾನ ಮಾಡಿ. ಅವ್ನು ತಪ್ಪಿತಸ್ಥ ಆದ್ರೆ ಬೇಗ ತೀರ್ಮಾನ ಮಾಡಿ ಕಲ್ ಶಿಕ್ಷೆ ಕೊಡಿ. ಯಾರು ಬೇಡ ಅಂತಾರೆ? Is it not? Why keeping it pending? No. See, at the end of the day, result is something different. Trial must be conducted. Even the utmost criminal yaridare, avaru kuda is also has got a right of speedy trial. The Honorable Supreme Court has said that the right to speedy trial is the right of an accused. More so when he is in custody. Even a person who is on bail is entitled for the speedy disposal. But when a person is in custody, that too from September 2019, what is the fun in keeping him further? Yes, Mr. 31-8. Ma, 31st August and Marco. Pass over. Natraj. ಅವ್ರು ಹೇಳಿ ಫಸ್ಟ್, ಮತ್ತೆ ನೀವೇ ಯಾಕೆ ಪ್ರಿಯಂಪ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ? This is case. You are only to aid the prosecution. You are not supposed to oppose the petition in the forum as if you are an adversary. Yes. For what? ಅವ್ರನ್ನ ವಜಾ ಮಾಡ್ತೀನಿ ಅಯ್ಯನ. ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೇಳಿ. ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದ್ದಾನೆ, ಟೈಮ್ ಕೊಡ್ಬೇಕು ಅಂತ ಕೇಳ್ತಿರಲ್ಲ, ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಏನ್ ಸರ್ ನೀವು? ಅವ್ರಿಗೆ ಆಯ್ತು, ಅವ್ರನ್ನ ಏಡಿಂಗ್ ದಿ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಕೊಡೋದಿಲ್ಲ ನಾನು. ನಿಮ್ ಕೇಸ್ ಹೇಳಿ ನೀವು. ಹೆಂಡತಿಗೆ ಹೊಡೆದಿದ್ದೀರಿ ಮಾರಣಾಂತಿಕವಾಗಿ, ಯಾಕೆ ಅಂತ? ಎಲ್ಲಿಗೆ ಮಾಡಿದಿರಿ? ಸ್ವಲ್ಪ ಗಾಯ ನಾನು ಸ್ವಲ್ಪ ಹೇಳುವಂತಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಓದಿ ದಯವಿಟ್ಟು. Commence the argument by reading the complaint. Kindly read complaint. Kindly read the complaint, sir.
ನನ್ನ ಮೊದಲು ಮನೆ ಕೆಲಸ ಮಾಡಿದ್ದು ಅಲ್ಲಿಯ ಆಟೋ ನನ್ನ ಮಗಳಿಗೆ ಮದುವೆಯಾಗಿ ಆಕೆಯ ಗಂಡ ಸಣ್ಣ ಪುಟ್ಟ ವಿಷಯಕ್ಕೆ ಗಲಾಟೆ ಮಾಡ್ತಿದ್ದೆ. ಆ ಮಾತಿಗೆ ಎಷ್ಟು ಬುದ್ಧಿಯಲ್ಲಿ ಬೇಡುತ್ತಿರಲಿಲ್ಲ. ಈಗ ಸುಮಾರು 3 ದಿನಗಳ ಇಲ್ಲಿ ಹೆಚ್ಚಾಗಿ ಗಲಾಟೆ ಮಾಡುತ್ತಿದ್ದು ನನ್ನ ಮಗಳು ಮತ್ತು ಅಲ್ಲಿಯ ನಮ್ಮ ವಾಸ ಮಾಡುತ್ತಿದ್ದೆ. ದಿನಾಂಕ 25/10/2020 ಸುಮಾರು 6 ಗಂಟೆಯಲ್ಲಿ ನಾನು ನಮ್ಮ ಮನೆಯ ಬಳಿ ಇರುವಾಗ ನಮ್ಮ ಮನೆಯ ಹತ್ತಿರ ಪಾತ್ರವಿರುವ ಶೇಖರ್ ಎಂಬ ಬಂದು ನನ್ನ ಮೊದಲಿಗೆ ಗಂಡ ಹುಟ್ಟಿಗೆ ಬಳಿ ಯಾವುದೋ ಆಯುಧದಿಂದ ಇದು ಗಾಯ ಮಾಡಿದ್ದು ರಕ್ತ ಸುರಿದಿದ್ದೆ. ಆಕೆಯನ್ನು ಅವರ ಅತ್ತೆ ಸರೋಜ ಹಾಗೂ ಬಾಬು ಮತ್ತು ವಸಂತ ಎಂಬುವರು ಚಿಕಿತ್ಸೆಯಿಂದ ಆಟೋದಲ್ಲಿ ನಾನು ಕೂಡಲೇ ಅವರ ಮನೆಯ ಮನೆ ಬಾಗಿಲು ರಕ್ತ ನನ್ನ ಅನಿಯ ಪ್ರತಿದಿನ ಅಂಜಲಿ ಮೇಲೆ ಗಲಾಟೆ ಮಾಡುವುದು ಕೊಲೆ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಅವರ ಗಾಯ ಮಾಡಿ ಕೊಲೆ ಮಾಡಲು
ಯಾಕೆ ಹೊಡೆದ್ರಿ ಕುತ್ತಿಗೆಗೆ? ರೀಡ್.
ನಂತರ ನನಗೆ ತಿಳಿದು ಬಂದಿದ್ದು ಏನಂದ್ರೆ, ನನ್ನ ಮಗಳು ಮಣಿವಾಳ ಕಾಕಿನಾಡ ಶ್ರೀನಿವಾಸ ದೇವಸ್ಥಾನದ ಇನ್ನೊಬ್ಬರಿರುವ ಜೋಸಫ್ ಎಂಬುವರ ಮನೆಯಲ್ಲಿ ಮನೆ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದು, ನನ್ನ ಮಗಳು ಮನೆ ಕೆಲಸಕ್ಕೆ ಹೋಗುವ ಜೋಸಫ್ ರವರ ಮನೆ ಮನೆಯಲ್ಲಿ ವಾಸಿಸುವ ಕೇರಳ ಎಂಬುವರು ನನ್ನ ಮಗಳಿಗೆ ಪರಿಚಯವಾಗಿದ್ದು, ಆತನ ಜೊತೆಯಲ್ಲಿ ನನ್ನ ಮಗಳು ಫೋಟೋ ತೆಗೆದುಕೊಂಡಿದ್ದು ಅದೇ ವಿಚಾರವನ್ನು ನನ್ನ ಅಲ್ಲಿಯ ಹೆಂಡತಿಗೆ ಅನುಮಾನ ಮಾಡಿ ಯಾವಾಗಲೂ ಹೆಂಡತಿ ಮೇಲೆ ಗಲಾಟೆ ಮಾಡಿ ಹೆಂಡತಿ ಮೇಲೆ ತುಂಬಾ ಅನುಮಾನ ಬಂದು ಆತನ ಕೆಲಸದವರು ಸಹ ಹೋಗದೆ ಮನೆಯಲ್ಲಿದ್ದು ಸಾಯಿಸಿ ಬಿಡ್ತೇನೆ, ನೀವು ಕೆಲಸಕ್ಕೆ ಹೋಗಬೇಡ, ಮನೆಯಲ್ಲಿ ಎಂದು ಕೇಳಿದ್ದನು. ಅವನು ನನ್ನ ಮಗಳ ಜೊತೆ ತೆಗೆದುಕೊಂಡಿದ್ದ ಫೋಟೋವನ್ನು ಸಿದ್ಧಾರ್ಥ ಕಾಲನಿಯ ಶಾಂತಿ ಕಳಿಸಿ ಎಂದು ಈ ವಿಷಯ ನನ್ನ ಅರಿವಿಗೆ ಗೊತ್ತಾಗಿ ದಿನಾಂಕ 25/10/2020 ಬೆಳಗ್ಗೆಯಿಂದ ಮನೆಯಿಂದ ಇದ್ದು ನನ್ನ ಫೋಟೋ ಸಿಕ್ಕಿಗೆ ವಿಚಾರ ತಿಳಿದಿದ್ದ. ಅದಕ್ಕೆ ನನ್ನ ಮಗಳು ಒಪ್ಪದೇ ಇದ್ದರಿಂದ ಇಬ್ಬರಿಗೂ ಗಲಾಟೆ ನಡೆದಿದ್ದು, ನಂತರ ಸಂಜೆ ಸುಮಾರು 4 ಗಂಟೆಯಲ್ಲಿ ಅವರು ಹೊರಗೆ ಹೋಗಿ ನಂತರ ಸಂಜೆ 6 ಗಂಟೆಗೆ ಮನೆಗೆ ನೀನು ನಿಜ ಹೇಳು ಸಂಬಂಧಿಸಿದೆಯಾ ಎಂದು ಕೇಳಿದಾಗ ನನ್ನ ಮಗಳು ನಿನ್ನ ಬಳಿ ಏನು ಇದೆ ಎಂದು ಹೇಳಿದಾಗ ನನ್ನ ಮಗಳು ಹೇಳು ನಿಜ. ನನ್ನ ಮಗಳು ಆತನ್ನು ನೋಡಿ ಆವರಿಯಾಗಿ ತಪ್ಪಾಯಿತು ಎಂದು ಇದ್ದುದರಿಂದ ಕಾಲಿಗೆ ಅವನು ನನ್ನ ಸಂಸಾರ ಹಾಳು ಮಾಡಿದೆ, ನನ್ನ ಮಗಳು ಹಾಳು ಮಾಡಿದ್ದೆ, ಮಗಳನ್ನು ಹಾಳು ಮಾಡಿದ್ರೆ ಈ ಹೇಳಿ ಅವನ ಪ್ಯಾಂಟ್ ಜೋಬಿನಲ್ಲಿ ನೀಡಿ ಮನೆಯ ವಿಶೇಷವಾದ ತೆಗೆದು ಇದೇ ವಿಭಾಗದಲ್ಲಿ ಮತ್ತು ಮಲ ಕೋಲಿನ ಮೇಲೆ ಮನೆಯಿಂದ ಕತ್ತರಿಯನ್ನು ತೆಗೆದುಕೊಂಡು ಮತ್ತೆ ಎದೆ ಭಾಗದಲ್ಲಿ ಬೆನ್ನಿನ ಮೇಲೆ ಇದು ಹಾಗೆ ರಕ್ತದಾಯ ಮಾಡಿ ಮರಣಾಂತದ ನೋಡಿ ಸಾಯಿಸಲು ಮನೆಯಿಂದ ಓದನೆಂದು ತಿಳಿಸಿ.
Yes, read the statement of the injured. ಅದನ್ನೇ ಹಾಕಿಲ್ಲ ನೀವು? Why have you not filed the statement of the injured, mister? Why have you not filed? Read it.
ಮನೆಯಲ್ಲಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿರುತ್ತೇನೆ. ನಮ್ಮ ಮನೆಯ ಹತ್ತಿರ ವಾಸವಿದ್ದ ಪಾರ್ವತಿ ಎಂಬುವನು ಆಟೋ ಓಡಿಸುತ್ತಿದ್ದು ಅನಂತರ ಸುಮಾರು 11 ವರ್ಷಗಳ ಹಿಂದೆ ಮಾಡಿಕೊಳ್ಳುತ್ತೇವೆ. ನಮ್ಮ ತಂದೆ ತಿಳಿದುಕೊಂಡು ನಮ್ಮ ತಾಯಿ ನಮ್ಮ ಮನೆಯ ಹತ್ತಿರವೇ ಮನೆಯಲ್ಲಿ ವಾಸ ಮಾಡುತ್ತಿದ್ದಾರೆ. ನಮಗೆ ದಾಸಿ ಎಂಬ 8 ವರ್ಷದ ಮಗಳು ಹಾಗೂ ಎಂಬ 6 ವರ್ಷದ ಇರುತ್ತಾರೆ. ನಾನು ಮನೆ ಕೆಲಸ ಹೋಗುವಾಗ ಅವರ ಮನೆಯ ನಿದ್ರೆ ಮಾಡಿ ವಾಸವಾಗಿರುವ ಕೇರಳ ವಾಸವಾಗಿರುವ ಇವರ ನನಗೆ ನಮ್ಮೂರು ಬಂದರೆ 2 ವರ್ಷಗಳ ಹಿಂದೆ ಒಬ್ಬರು ನಂತರ ನಾನು ಆತನ ಜೊತೆಯಲ್ಲಿ ಸಂಬಂಧ ಇಟ್ಟುಕೊಂಡಿರುತ್ತೇನೆ. ಇದು ಬಾರಿ ನನ್ನ ಜೊತೆಯಲ್ಲಿ ನಿಲ್ಲಿಸಿಕೊಂಡು ಅವನ ಮೊಬೈಲ್ನಲ್ಲಿ ತೆಗೆದುಕೊಂಡ ವಿಚಾರದಲ್ಲಿ ನನ್ನ ಗಂಡ ಮೇಲೆ ಅನುಮಾನವನ್ನು ಬಂದು ನನ್ನ ಮೇಲೆ ಯಾವಾಗಲೂ ಗಲಾಟ ಮಾಡಿ ಹೊಡೆಯುತ್ತಿದ್ದರು. ಇತ್ತೀಚೆಗೆ ನನ್ನ ಮೇಲೆ ತುಂಬಾ ಅನುಮಾನ ಬಂದು ನನ್ನ ಗಂಡ ಕೆಲಸಕ್ಕೂ ಹೋಗದೆ ಮನೆಯಲ್ಲೇ ಇದ್ದು ನನ್ನ ಸಾಯಿಸಿಬಿಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಕೆಲಸಕ್ಕೆ ಹೋಗೋದೇ ಬೇಡ, ಮನೆಯಲ್ಲೇ ಇರು ಎಂದು ಹೇಳಿಸಿದ್ದನು. 15 ದಿನಗಳ ಹಿಂದೆ ನಾನು ಸ್ವಂತ ಊರು ಕೇರಳಕ್ಕೆ ಹೋಗಿರುತ್ತಾನೆ. ಆದರೆ ನನ್ನ ಜೊತೆ ತೆಗೆದುಕೊಂಡಿದ್ದ ಫೋಟೋವನ್ನು ನಮ್ಮ ಮನೆಯ ಇರುವ ನನ್ನ ಸ್ನೇಹಿತಿ ಸಾಕಿ ನೆರಳಿ ನನ್ನ ಮನೆ ಕೆಲಸದಲ್ಲಿ ನನ್ನ ಕುಟುಂಬದ ಜೊತೆಯಲ್ಲಿ ಫೋಟೋ ಇರಿಸಿ ನನಗೆ ಫೋಟೋ ಸಿಕ್ಕಿದೆ ಎಲ್ಲ ಹೇಳಿ ಎಂದು ಕೇಳುತ್ತಿದ್ದರು. ಈಗ ಗಲಾಟ ಮಾಡಿ ನನ್ನನ್ನೇ ಮನೆಯ ಎಲ್ಲಿಗೂ ನನಗೆ ನಂತರ ಸಂಜೆ ಸುಮಾರು 4 ಗಂಟೆಗೆ ಹೊರಗೆ ಹೋಗಿ ಬಂದು ಸಂಜೆ ಸುಮಾರು 6 ಗಂಟೆಗೆ ನನಗೆ ನೀವು ಮುಂದೆ ಹೇಳಬಹುದು ನಿಮಗೆ ನನ್ನ ಬಳಿ ಏನು ಹೇಳಿದ್ದೆ. ನಾವು ಕುಟುಂಬದ ಜೊತೆಯಲ್ಲಿ ತೆಗೆದುಕೊಂಡ ಫೋಟೋವನ್ನು ನನಗೆ ತೋರಿಸಿ ಹೀಗೆ ಹೇಳಿ ಎಂದು ಇಲ್ಲ ಅನುಭವವನ್ನು ನನಗೆ ಎದುರಿಸಿ ನೋಡಿ ಅವರಿಂದ ತಪ್ಪಾಗಿದೆ ಎಂದು ಕಾಲಿಗೆ ಬಿದ್ದು ಆಗ ನನ್ನ ಸಂಸಾರ ಹಾಳು ಮಾಡಿ ನನ್ನ ಹಾಳು ಮಾಡಿ ಮಕ್ಕಳು ಹಾಳು ಮಾಡಿ ನೀನು ಬಿಡುವುದಿಲ್ಲ ಹೇಳಿ ಲೋಕದಲ್ಲಿ ನೀಲಿ ಬಣ್ಣದ ಕಟ್ಟಲು ಬಲಭಾಗದ ಕಟ್ಟಿಗೆ ಹಾಗೂ ಭಾಗದಲ್ಲಿ ನಂತರ ಮನೆಯಲ್ಲಿ ಪತ್ರಿಕೆಯನ್ನು ತೆಗೆದುಕೊಂಡು ಮತ್ತು ನನ್ನ ಮಾಡಿ ಮರಣಾಂತಿಕ ಮಾಡಿ I would like to see on the whole.
Yes, Barkoli, heard. Counsel for the petitioner and learned HGP. First, an application is filed by the de facto complainant seeking aiding of the prosecution, seeking permission of the court to aid the prosecution. First, since this court is inclined to dispose of the petition on merits, application filed by the de facto complainant to aid the prosecution is not necessary. First, hence IA so and so is disposed of. First, next para. Present petition is filed and the brief facts of the case are ascended upon the complaint lodged by the mother of the injured, Madiwala police have registered a case in crime number 158 of 2021 for the offence punishable under section 307 IPC. First, in the complaint, it is contended that injured is the daughter of the complainant and she was married to the accused petitioner. First, 11 years earlier. First, they have two children. First, in the meantime, the accused petitioner suspected the fidelity of the injured, stating that she has got a relationship with one Abu Bakr, and on account of the same, he nurtured ill will. And on 25/10/2021, he has assaulted the injured with a sharp-edged weapon on the neck, chest, and on the abdomen region. And she was shifted to St. John's Hospital. First, subsequent thereto, a further statement came to be recorded by the police, wherein it has been stated that the accused has assaulted with a radium cutter and also with a scissor to the injured on account of the fact that the photograph of the injured taken along with Abu Bakr is sent to the mobile telephone of Srimati Shanta, and based on the same, the accused has decided to take the revenge on his wife and assaulted her. First, police, after registering the case, conducted a thorough investigation and filed charge sheet against the petitioner herein. First, next para. Accused was arrested on Accused was arrested during the course of investigation and he approached the district court for grant of bail. The same was rejected by the Learned District Judge in Simis number 59/2022 by order dated 7th January 2022. Thereafter, petitioner is before this court. First, net para. Reiterating the bail grounds, Lord Counsel for the petitioner Sri Nataraj vehemently contended that the petitioner is innocent of the offences alleged against him and a trivial incident has been blown out of proportion by the prosecution by invoking section 307 IPC and therefore sought for grant of bail. First, I further contended that the injuries sustained by the petitioner by the injured are not on account of the assault made by him and therefore sought for grant of bail. Per contra, and HGP opposes the bail petition on the ground that the statement of the injured witness clarifies that on account of the ill will developed by the petitioner, assaulted the petitioner, he has assaulted, developed by the petitioner against the injured, petitioner has assaulted the injured with a radium cutter and also with scissors on chest, neck, and abdomen, which are all vital parts of the body, and the weapon is a deadly weapon, and therefore all ingredients to attract the offence under section 307 IPC is prima facie made out, and therefore petitioner is not entitled for grant of bail by resorting to the special powers vested in this court. First up, next para. Those is the material on record. The material on record meticulously the trial contentions of the parties. First up, next para. Admittedly, the injured was married to the petitioner herein about 11 years earlier, and they have two children. First up, there is a dispute as to the there is a strained injured. First, petitioner suspects the illegal illicit relationship between the injured and Abu Bakr. First, there is a photograph taken by Abu Bakr which was circulated in the locality to the locality and which came to the knowledge of the petitioner herein through the mobile telephone of Srimati Shanta. First, next para. When the matter stood thus, the accused with an intention to take away the life of the petitioner, life of the injured, assaulted her with a radium cutter on 25/10/2021 on her neck, and also took a scissor and assaulted on her chest region number of times, and also stabbed to the stomach. First, the injuries sustained by the injured amply proves the same. First, the charge sheet is filed and material in the charge sheet are prima facie attracting the offence under section 307 IPC. It is for the petitioner to establish his innocence before the court during the trial. First, suffice to say that the material available on record in the form of the wound certificate and the testimony of the injured eyewitness, that of the other witnesses who have shifted the injured to the hospital, would disentitle the petitioner from obtaining an order of grant of bail by resorting to the special powers vested in this court under section 439 CRPC. Accordingly, following order is passed, petition is dismissed. However, having regard to the fact that accused is in custody, trial court is directed to expedite the trial. Also, Chandrahasa Rai, ಹೇಳಿ ನಟರಾಜ್ ಇದೇನು ಕೊಡಿ ಏನ್ ಮ್ಯಾಟ್ರ್ ಅದು 406 408 420 yes
along with the other the company taking the advance amount of the claims. Then in this case, accused number 2 has been already taken.
ಕಸ್ಟೋಡಿಯಲ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಬೇಕಾಗತ್ತಲ್ಲ ನಿಮ್ದು. ತಾಪಸಿ ಮೋಟಾರ್ಸ್ ಮೊನ್ನೆ ಮಾಡಿದ್ವಲ್ರಿ, ಯಾವ್ದದು ನಂಬರು? ತಾಪಸಿ ಮೋಟಾರ್ಸ್ ಅಂತ ಮಾಡಿದ್ವಲ್ರಿ ಮೊನ್ನೆ. ಅವ್ರದ್ದು ಯಾವತ್ತೋ ನೀವು ಹೋಗಿ ಅವತ್ತೇ ಜಾಯಿನ್ ಆಗಿ, ಯಾವತ್ತಿದೆ ನೋಡ್ರಿ ನಂಬರ್ ಹೇಳಿ, ನೋಡ್ರಿ ನಂಬರ್ ತಗೊಂಡು ಏನ್ ಮಾಡ್ತಾ ಕೂತಿದ್ದಾರೆ ಅವತ್ತು. This court had Sri Nataraj and learned HGP. First, the brief facts of the case are they had so and so. The present petition is under section 438 CRPC. ಏನಾಗಿದೆ ನೋಡಿ ಅಲ್ಲಿ ಯಾವ ಡೇಟು, ಅದರ ಫೈನಲ್ ಆರ್ಡರ್ ಇದೆ ನೋಡಿ. Brief facts of the case are as under. Upon a complaint lodged by ಯಾವತ್ತಿಗೆ ಹೋಗಿ ಕೇಳಿದ್ವಿ ನೋಡಿ, N. Varshita, HR manager of Tapasi Kia Motors Private Limited. A case came to be registered by Banaswadi Police in crime number 475 of 2021 on 8/10/2021. In the complaint, it is contended and taken from the prospective customers who are fake customers, there is a misappropriation to the tune of 10 lakhs in the company, and the petitioner is also involved in the same and sought for action. First, after registering the case, police are investigating the matter. Petitioner approached the district court for grant of bail, which was turned down by the order dated 27 January 2022 by Additional District Judge Bangalore City in semis number 553 of 2022. Thereafter, petitioner is before this court. First, land counsel for the petitioner Nataraj submitted at the outset submitted that stated so granted the anticipatory bail to the co-accused in the same crime, and present petitioner also stands on the same footing, and therefore he also be enlarged on anticipatory bail. First, learned HGP did not dispute the said aspect of the matter. Accordingly, without discussing further on the merits of the matter, the present petitioner is also entitled for the similar order that of the petitioner in series number so and so. Accordingly, following order is passed same as note from ಮಾಡುತ್ತೇವೆ. 7ನೇ ತಾರೀಕು ಹೋಗಿ ಕಸ್ಟಡಿಗೆ ಸೇರ್ಕೊಳ್ಳಿ. ಆರ್ಡರ್ ತಗೊಳ್ಳಿ. 7 ನಮ್ಮ ಚೇಂಬರ್ ನಲ್ಲಿ ಯಾವುದು ಇವತ್ತಾಗಿದ್ದು ಇವತ್ತೇ ಸೈನ್ ಆಗುತ್ತೆ. ಅಟ್ ದಿ ಮೋಸ್ಟ್ ಅಂತಂದ್ರೆ ನೆನ್ನೆ ಸಾಯಂಕಾಲ ಕೊಟ್ಟಿದ್ರೆ ಇವತ್ತು ಬೆಳಗ್ಗೆ ಸೈನ್ ಆಗಿರುತ್ತೆ. ಯಾವುದನ್ನು ಇದುವರೆಗೆ ತನಕ ಕಾಪಿ ಪೆಂಡಿಂಗ್ ಇಲ್ಲ. ಆಯ್ತಲ್ಲ, ನಮ್ ಚೇಂಬರ್ ನಲ್ಲಿ ಯಾವ್ದು ಪೆಂಡಿಂಗ್ ಇಲ್ಲ. ಏನಾಗಿದೆ ನೋಡಿ. 7 so and so. Pass over. Pass over. ಹೇಳಿಮ್ಮ.
They will not check this documents. They have received a call at 12:21 and the complaint is brought up by them. It is a 1 month. They have forwarded 1 crore lakhs. Now contact the documents check. But they have deposited 1 crore lakhs.
Yes.
Based on that,
Yes. Where is the PAN card, GST copy, KYC? Which you have produced, which you have given it them and produce it here. We will verify whether it is a original or not. We will verify. ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಸುಳ್ಳು ಪ್ಯಾನ್ ಕಾರ್ಡ್, ಫೇಕ್ ಪ್ಯಾನ್ ಕಾರ್ಡ್. Only 13 lakhs has been received. No, please. Only 13 lakhs has been recovered from the account. What happened to the remaining 1 crore? It's all through the bank. It's all through the bank, madam. It's all through the bank. It's all through the bank. Transactions are reflected. What is it that you have stated? Please read column number 17. You read it. Don't say something which is incorrect. ಕಂಪನಿ ಖಾತೆಯಿಂದ ಆರೋಪಿಯ ಸದರಿ ಖಾತೆಗೆ ಎಸ್ ಬ್ಯಾಂಕ್ ಖಾತೆಗೆ ಹಣವನ್ನು RTGS ಮುಖಾಂತರ 28/9/29 ಪಾವತಿ ಮಾಡಿರುತ್ತಾರೆ. Don't read the papers properly. ಆಯ್ತು, ಸಾಲ್ದಾ? ಅದನ್ನೇ ಕೊಡಿ ವಾಪಸ್ಸು. ಎಲ್ಲಿ ಮೆಷಿನರಿ? ಅಲ್ಲಮ್ಮ, ಎಲ್ಲಿ ಮೆಷಿನರಿ? ಎಲ್ಲಿ? Not immediate. 12:10. ಮೆಷಿನರಿ ಬರ್ದಲ್ನೆ ದುಡ್ಡು ಹಾಕಿಸ್ಕೊಂಡ್ರಿ. No, sorry. No, sorry. Yes. ಬರ್ಕೊಳ್ಳಿ. ಹರ್ಡ್. ತಮ್ಮ ಹೆಸರೇನು? So and so and learned HGP. Present petition is under section 439 CRP. If you have settled the matter, they would not have filed the complaint. You have cheated them. You have cheated them. Fake PAN card. fake PAN card, fake KYC. They have all verified. Police have verified that the PAN card given by you. No such PAN card exists. ಒಳ್ಳೆ ಚೆನ್ನಾಗಾಯ್ತಲ್ಲ, ನೀವ್ ಹೇಳ್ಬೇಕು ಏನ್ ಪಾತ್ರ ಇದೆ ಅಂತ. ಅದೆಲ್ಲ ಅಲ್ಲಿ ಗೊತ್ತಾಗತ್ತೆ ಟ್ರಯಲ್ ನಲ್ಲಿ ಪಾತ್ರ ಏನು. No, sorry. They will have to be there unless you repay the money or give the machinery. You will have to be there for all time to come. You have cheated the man, taking 50 lakhs of rupees, 1 crore total. Yes, heard so and so and learned HGP. Present petition is filed under section 439 CRPC. Three facts of the case are as under. A complaint came to be lodged by Hemant Pradhan, representing himself as Yenavurali, Tora Cargo, authorized representative of Tora Cargo Shipping. Aita, Tora Cargo Shipping. Posta. In the complaint, it is contended that his company is freight forwarding and logistics company, and on 12/9/2021, he received a call from John Kennedy and Seema. They said that they would help the company in importing the spare parts of a machinery. Posta. They also represented to the complainant that they have a shipping company and a vessel. Posta. Based on the words, comma, believing the words of the John Kennedy and Seema, comma, the complaint company transferred 1 crore 31 lakhs 4,233 rupees for the purpose of importing the spare parts of a machinery. Posta. After receipt of the same, comma, there was no communication from the John Kennedy and Seema, comma, therefore the complaint was lodged to take action. Posta. After registering the case in crime number 299 of 2021, comma, Kerpuram police investigated the matter and apprehended the petitioner. Posta. After thorough investigation, comma, the police have also filed charge sheet against the petitioner and another for the offences punishable under section 406, 420, 120B, section 34 IPC. Posta. Next para. That counsel for the in the meantime, comma, petitioner approached the district court for grant of bail under section 439 CRPC. Same was turned down by the learned district judge by order dated 18 January 2022 in series number 303 of 2022. Posta. Thereafter, petitioner is before this court. Posta. In the petition, following grounds have been raised. Reiterating the above grounds, comma, that counsel for the petitioner vehemently contended that since the charge sheet is now filed, continuation of the accused in judicial custody is no longer warranted. Posta. He further contended that the material on record would not disentitle the petitioner from obtaining an order of grant of bail by resorting to the special powers vested in court on section 439 CRPC, and the continuation of the accused in judicial custody would amount to pre-trial conviction and sought for grant of bail. Posta. Per contra, next para. HCGP opposes the bail petition, stating that per se the documents given by the petitioner is fake documents. They have gone to the extent of producing the fake PAN card and other related documents, which shows that there was an intention to cheat the complaint company at the inception itself. Posta. The amount has been transferred to the bank account, and therefore prima facie all ingredients to attract the offence alleged against the petitioner stands established from charge sheet materials and sought for dismissal of the bail petition. Posta. Next para. In of the rival contentions of the parties, comma, this court perused the material on record meticulously. Posta. Next para. It's an admitted fact that the John Kennedy and Seema contacted the complainant company for the purpose of helping them out in importing spare parts of the machinery, representing that they own a shipping company and also a vessel of their own. Posta. Based on the words and other documents which were produced to the complainant company, comma, complaint company transferred huge amount of money to the tune of 1 crore so and so through the bank account. First, next para. Subsequent thereto, when there was no delivery of the machinery as sought for, machinery and spare parts as sought for, the complaint tried to contact the said persons repeatedly, but there was cold response from the petitioner and another. First, accordingly, complainant was constrained to approach the police. First, police, after thorough investigation, not only apprehended the petitioner and another person involved in the petitioner and others involved in the incident, but also found was able to recover only 13 lakhs out of 1 crore and odd, and balance amount is already misappropriated by the petitioner and others. First, the matter is pending before the trial. The charge sheet is now filed. Expressing any opinion on merits of the matter at this stage would definitely interfere with the rights of the parties during the trial, one way or the other. Accordingly, desisting from holding the mini trial, this court is of the constant opinion that no grounds are made out to enlarge the petitioner on bail by resorting to the special powers vested in this court under section 439 CRPC. Accordingly, following order is passed, petition dismissed. Yes, please.
Parity. Is
Hmm. Roll in.
Driven the vehicle, but the gas in the vehicle and went down. It is 6 to 9. 6, 7, 8. 4 to 5 assaulted the injured and committed murder. One is that the accused number 6, 8 and 7 was sitting in the Tata vehicle. A6 was driving the vehicle, so A6 was rejected by the earlier dishonorable court. But A8 was granted because he was sitting in the side of the A6. Petition is also standing in the same footing for us.
Yes, mister. He was also in the car. Accused number 6 has been verbally heard. Sri Shashidhara and Learned HGP. Present petition under section 439 CRPC. First, with the following prayer. First, brief facts of the case are ascended. First, complainant Satish registered a crime in crime number 67 of lodged a complaint which was registered in crime number 67 of 2021 on 4/10/2021 by ಯಾವ police ಇದು Jamgondlo police. First, in the complaint it is contended that Jai Sri Ram was proceeding on a motorcycle and a Tata Ace vehicle dashed against the said motorcycle from the hind side, and whereby the motorcyclist fell down, whereby the pillion rider fell down and sustained fatal injuries and died. First, after a while, accused number 2 to 5 came in a car and assaulted the pillion rider and committed murder of Jai Sri Ram. First, after registering the case, against the unknown persons, police investigated the matter and arrested the accused persons, including the present accused, who is accused number 7. First, next para. Accused approached the district court for grant of bail, which was turned down by the learned district judge in CMIS number 127 of 2022 on 17/11/2021. First, thereafter petitioner is before on 27th January 2022. 27th January 2022. First, next para. Thereafter petitioner is before This court, first of Learned Counsel for the petitioner Sri Shashidhara vehemently contended that similarly placed accused number 6 has been enlarged. Similarly placed accused number 6 has been accused number 6. Accused number 8 has been enlarged on bail by this court in criminal petition number 664 of 2022 by order dated 4th February 2022 by this court, by coordinate bench of this court and court. Next para. And therefore, without further discussion on the merits of the matter, petitioner is entitled to be enlarged on bail on the ground of parity. However, learned HGP opposes the bail petition, stating that role assigned to the present petitioner is different from the role assigned to the person who has been enlarged on bail by filing written objections. First, next for any of the rival contentions, this court whether the better law on record, including the order passed by this court in criminal petition number, order passed by coordinate bench of this court in criminal petition number 664 of 2022 dated 4th February 2022 and the objection statement. First, on such perusal, this court is satisfied that the present petitioner, who is accused number 7, stands on the same footing that of the accused number 8, who has been enlarged on bail. Accordingly, without further discussion on the merits of the matter, this petitioner is entitled to be enlarged on bail on the ground of parity alone. First, accordingly, following orders passed. Yes, Mr. Rajshekar. Hmm. 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 Yes, please. Hmm. All right, what is the age of the victim girl? That's it. What can be done? See, if assuming that the victim girl is a consenting party, her consent cannot be taken as a legal consent in view of the judgment of the Honorable Apex Court, independent thought. Yes. And it's a case of joint venture. Complete the trial. If the victim girl doesn't support the trial, they're instrument. Yes, file a memo. Memo filed after hearing for some time. Sri Rajshekar, Land Counsel for the petitioner, files a memo. Memo reads as under in view of the memo, petition is dismissed as withdrawn with liberty as prayed for. Yes, please. Hmm. Hmm. Yes.
Like ATM, Abhishek Kumar, 42 ATM access
2,50,000.
Actually, tax is clear. And every year there is not going to office. This can be assessed as complaint letter. Due to the dishonest intention and act of conduct. That will affect its learning and further can also impact the public. The above staff have done criminal misappropriation, misappropriation, product property. View of the above is something requested that the above facts may be investigated by your office and take appropriate action. Misappropriated by at least
Yeah.
for which the entire study
Yes.
by the offices that not
Who are you? You are the person who was custodian of the entire money. Yes, Parkoli, heard. Sri Shashidhar KN and Learned HGP. First up. The present petition is under section 438 CRPC with the following prayer. First up, next para. Brief facts of the case are as under. Upon a complaint lodged by Suresh Kumar, son of Kondaya, Kadugondanahalli Police registered a case in crime number 415 of 2021 on 24/12/2021. In the complaint, it is contended that where is the complaint copy? Secure value. And the complaint, it is contended that the complainant is the authorized representative of Messrs. Secure Value India Limited, which is doing its business in cash management services. First up, cash management services to the public sector and private sector banks. First up, the accused is one of the employees who was entrusted with the work of loading the cash to the ATM. First up, the money was given to the custody of the petitioner to be loaded into Yav sector, to be loaded into ATM in route number 12. First up, route number 52. First up. However, without loading the ATMs with the money, on 5th July 2021, misused the same, and there was a shortage of 12,50,100 in respect of Axis Bank ATM SW CW 5611. First up. Immediately, the matter was reported, and on 6/7/2021, the complaint came to be lodged. First up, after registering the case, police are investigating the matter. Petitioner is absconding, and as such, the investigation has crippled. First up, the attempt made by the petitioner to seek grant of anticipatory bail was turned down by the learned district judge in semis number 437 of 2022 by order dated 19 January 2022. Thereafter, petitioner is before this court. First up, next para. That counsel for the petitioner, reiterating the bail grounds, contended that petitioner is no way responsible with the alleged crime and he has been falsely implicated in the incident. First up, he further contended that the petitioner is a law-abiding citizen and he is having real apprehension of arrest, and he be enlarged on he be granted anticipatory bail. First up, Parkantal and HGP opposes the bail petition on the ground that the amount of misappropriation is to the tune of rupees 12,50,000, 50,000 and the petitioner was in charge of the 50,100 and petitioner was in charge of the said money and he was supposed to fill the ATMs in route number 52 and without filling the route the money to the ATM, he has misappropriated and the same is found by the higher officials on regular audit and on 5/7/2021 and accordingly the complaint came to be lodged on 6/7/2021 and custodial investigation of the petitioner is utmost necessity for unearthing the truth in the incident and sought for rejection of the bail. First, this court perused the matter on record meticulously in the rival contention of the parties. First, on such perusal of the matter on record, it is admitted fact that the petitioner was working in secure value so and so limited as a ATMO. First, the money was handed over to him for filling it in the ATM. First, on audit, it is found that there was a shortage of 12,50,100 in respect of ATM, Axis Bank ATM, Axis ATM bearing number SWCW 56111. First, it is for the petitioner to fill the money in the said ATM and audit report clearly shows that there was a shortage. First, after registering the case, the petitioner is absconding. First, presence of the petitioner to unearth the truth and custodial investigation is very much necessary. Therefore, no grounds are made out for granting the anticipatory bail to the petitioner. Hence, following order, petition rejected. Mohammed Pasha, pass over. Yes. See, Jagdish, ಯಾವತ್ತು ಹಾಕಿದಿರಿ? ಅದ್ಯಾಕೆ ಅಷ್ಟು ದಿನ ಮಾಡ್ತಾರೆ? ಮೊನ್ನೆ ಕೇಳಿದಿರಲ್ಲ ಅದನ್ನ. At request of counsel for petitioner, release this matter on 8/4. 13/4. Manjunatha. Dinabandhurai.
Plus, I appeal for the petition in this case, please. Plus, petition 38 for bail, please, Manoj.
Yes, Mr. Naik.
Please, Manoj. The petition, please, Manoj, is the managing partner of Pinnacle Acres and Ventures, please, Manoj, which is involved in the business of procuring lands for the development, formation of sites, and undertaking projects coordinating between sellers and buyers of the lands in question. Plus,
Yes.
the complainant in the instant case, SJK Builders, please, Manoj, wanted to develop a land in question, please, Manoj, and form sites in Kesre village. As such, please, Manoj, they requested the petitioner for the purposes of acquisition of the properties in question for aggregating the properties in question, please, Manoj. There is an MOU, please, Manoj, entered into between the petitioner and the complainant in question. As per the agreement in question, please, Manoj, the respondent complainant, please, Manoj, advanced 13.5 crores for the purposes of acquisition of the properties. 26 acres of the properties was acquired, please, Manoj, was aggregated for the purposes of the layout. Then thereafter, please, Manoj, totally an extent of 50 acres was to be aggregated. When the process of aggregation was still on, a complaint came to be registered to the effect that the accused in question, please, Manoj, has purchased the property in his name and in the name of his company instead in the name of the complainant, please, Manoj. The MOU which I have produced would clearly indicate, please, Manoj, that the property could be purchased only in the name of the petitioner and not in the name of the complainant, please, Manoj. The MOU has been produced, please, Manoj, along with a memo by me. Your lordship may kindly peruse the same.
Yes.
MOU along with the memo, please, Manoj, I have produced.
Yes.
On page number 9 of the MOU, please, Manoj, at the bottom, the page numbers are mentioned.
Yes,
Page number, mode of purchase.
yes,
Paragraph number 2. The second party, that is the petitioner herein, is entitled to get any deeds, documents, papers, or such things, whether under the agreement for sale or under GPS or in any other manner, mode, in his name or in the names of anybody to his order from the landowners, and whatever such deeds, documents, papers are done shall be deemed done for and on behalf of the first party, that cannot be denied or refused by the first party later on. Unless there is one other clause, please, minutes in the same MOU, which goes to establish, please, minutes that it is the petitioner who can purchase the property in question in his own name, please, minutes.
yes.
That is
You
found.
go and appear before the investigation agency for a day. Let the custodial investigation, if any, be completed on the same day.
For the same, on the same day, I will be doing it.
Yes, Barkoli, heard. Shri Ravi B. Nayak, learned senior counsel and learned HDP. Present petition is filed under section 438 CRPC with the following prayer. Three facts of the case are as under. Upon the complaint lodged by Shri Dureswamy MN, late Nagendra, Narsimharaja police have registered a case in crime number 7/2022 on 12/1/2022 for the following offences. 506, 504, page number, next area, page number 10. First, next para. The brief facts of the complaint governments reveal that the complainant, being the managing partner of Jayakrishna Builders and Developers, entered into an agreement with the accused Costa. As per the agreement dated 4/7/2017, there is a breach of the agreement conditions, and also there is a cheating that has taken place, and the same amounts to criminal breach of trust, and therefore sought for action against the petitioners, herein. First, next para. After registering the case, police are investigating the matter. First, for want of presence of the petitioner, investigation has crippled. First, in the meantime, petitioner approached the district court for a prayer for grant of anticipatory bail in semis number 109 of 2022. First, learned district judge, 4th additional, 6th additional district judge by order dated 1st February, 6th additional district judge Mysuru by order dated 1st February 2022 rejected the prayer made by the petitioner, and thereafter petitioner is before this court. Reiterating the bail grounds are in the petition, Shri Ravi B. Nayak, learned senior counsel, vehemently contended that petitioner is a law-abiding citizen and absolutely there is no iota of truth in the complaint governments, and the entire obligations are covered by the joint development agreement. A memorandum of understanding signed by the petitioner and Messrs. SJK Builders and Developers, and therefore, in order to coerce the petitioner to agree for illegal demands in terms of the agreement, a false criminal case has been filed and sought for grant of anticipatory bail. First, per contra, and HGP opposes the bail petition, stating that the material on record sufficiently established, prima facie established that there is a commission of the offense of section 420 by the petitioner herein, and therefore sought for rejection of the bail. First, peruse the material on record meticulously, note the rival condition of the parties. First, admittedly, there is an agreement between the petitioner and complainant in respect of development of the land. First, the matter per se appears to be civil in nature. Nevertheless, since the amount, the money is also involved, there is an allegation that there is a criminal breach of trust and also cheating by the petitioner herein. These matters require custodial investigation to unearth the truth in the matter. Therefore, there is sufficient force in the argument put forth on behalf of the HGP that petitioner is required to be interrogated by taking him to custody. At the same time, since it's a matter of civil in nature, prima facie, the right of the petitioner also to be protected pending dispute between the right of the petitioner to be protected pending adjudication of the alleged complaint and pending investigation and adjudication of the alleged criminal complaint. First, accordingly, without expressing further opinion on the merits of the matter, following order is passed. Question allowed. Petitioner is directed to join the investigation by appearing before the investigation agency on 8th of April 2022 at 10 a.m. First, the investigation officer is at liberty to take the petitioner to custody and complete the custodial investigation, if any, on the same day before 7 p.m. First, thereafter, enlarge the petitioner on bail and by taking a bond in a sum of rupees 1 lakh with 2 sureties for the like sum. Our directions is there. He shall not leave the jurisdiction of Mysore court without prior permission.
Please.
Yes.
Oblige.
Yes. Tell you, madam. You want time? All right. ಈಗ ರೆಡಿ ಇದೀರ್ ತಾನೆ ಹೇಳಿ ಆರ್ಗ್ಯುಮೆಂಟ್.
The petitioner has created a extra amount. Last for the complaint plus of financial.
ದುಡ್ಡೆಲ್ಲ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರಲ್ಲ, 1-2 ರೂಪಾಯಿ ಅಲ್ಲ, 12 ಲಕ್ಷ ರೂಪಾಯಿ ಹುಡುಗಿ ಫೋಟೋ ಹಾಕೊಂಡು ಮೋಸ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಸೊ ಹಾಟ್ ನಾಳೆ ಬಂದು ಇನ್ನೊಂದು ಫೋಟೋ ಹಾಕೊಳ್ಳಲ್ಲ ಅನ್ನೋದು ಗ್ಯಾರಂಟಿ ಏನು? ಅವನ್ ಯಾರ ಪಾಪ ಪೆದ್ದ, ಬರೀ ಫೋಟೋ ನೋಡಿ 12 ಲಕ್ಷ ರೂಪಾಯಿ ಕಳ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾನೆ. What to do? Why do you want him to continue in the custody? To file your objections. Kodi. Then HGP files objections. Release this matter on 8/4, 13/4. 13/4. Find out whether he is involved in similar offences or any other aspects. Find out. ತುಂಬಾ ಅಕೌಂಟ್ ಜನಕ್ಕೆ ಇದೇನೋ ಒಬ್ಬನೇ ಗೊತ್ತಾಗಿದೆ, ತುಂಬಾ ಜನಕ್ಕೂ ಮೋಸ ಮಾಡಿರ್ಬೋದಲ್ಲ. ಆಲ್ ರೈಟ್, ವಿಲ್ ಸಿ. ಜಯಂತ್ ರಂಗಣ್ಣ ರೆಡ್ಡಿ ಅವರು, ಎಸ್ ಪ್ಲೀಸ್. ರೆಡ್ಡಿ ಅವರೇ, ಎಸ್ ಪ್ಲೀಸ್. ಎಸ್ ಪ್ಲೀಸ್. What is the age of the victim girl? Yes, please. Yes. ಅದಾದ್ಮೇಲೆ ಬಿಡಕ್ಕೆ 30,000 ರೂಪಾಯಿ ಬೇರೆ ದುಡ್ಡು ಕೇಳಿದ್ದಾರೆ. No, she has stated, no? Kindly see page number 40, 41. No, 41 you kindly read. ಮರುಹೇಳಿಕೆ ಸರಿ. What about the statement made before the magistrate? How can the police take ಮರುಹೇಳಿಕೆ? No, kindly read page number 41. How can police record a statement again against the 164 statement? Sir, if at all, if the retraction of any statement made before the magistrate, it should be again before the magistrate, not before the IO. ಓದ್ ಕೊಟ್ಟಿರ್ತಾರಲ್ವಾ ಇಲ್ಲಿ, ಮತ್ತೆ IO ನಲ್ಲಿ ಓದ್ತಿರುತ್ತಾ? 161 ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲಿ ನೀವು 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ನ ಕಿತ್ತಕ್ಕಾಗುತ್ತಾ? Can you efface the effect of a statement recorded under section 164 CRPC by taking a further statement under 161. No value, no? Yes, Barkoli. Hard. Sir, that is not before the, not question of court nalli belada IO madak baralla. IO can't record the statement. We'll hold the IO responsible. How can you take a statement of a victim girl after she deposes before the court? Who is the IO, mister? Who is the IO? Who is the IO? Get him here. Get him here. How can you do that? No, that's why, who is the IO? These things must be stopped by the police. Who is the IO? What authority he has got? It is straight away interfering with the court proceedings, amounts to criminal contempt. We'll register the criminal complaint against the IO. Yes, who is the IO? Shilpa YS. Get her. Barkoli. Want that to happen? Or shall we leave it at this? Henry, or who is she, I say? Court proceedings nalla interfere mattare. What right she has got? What right she has got to record the further statement, to nullify the statement of the made by the victim girl before the court? ಕರ್ಸಿ ಅದನ್ನ ಆಮೇಲೆ ಮಾಡೋದಾಗ್ಲಿ, ಒಂದು ಅಪಾಲಜಿ ತಗೊಳ್ಳಂತ ತಗೊಳ್ಳಿ, ಬರ್ಕೊಳ್ಳಿ. During the course of hearing, it is noticed that the victim girl has given her statement before the jurisdictional magistrate Davangere under section 164 of CRPC Posta. The investigation officer, Srimati Shilpa YS of Women PS Davangere, on the same day recorded a further statement of the victim girl, which is practically nullifying the statement given by the victim girl before the learned magistrate under section 164 CRPC, purportedly in the form of further statement recorded under section 161 CRPC Posta. The said action on the part of the investigation officer is totally uncalled for. Per se, it amounts to interference with the judicial proceedings Posta. Therefore, the investigation officer, Srimati Shilpa YS, who was then the PI of Women Police Davangere, is ordered to be present before the court with the case diary on next date of hearing. Posta. Copy of this order be made available to the learned HCGP to secure her presence through Home Secretary. ಆಮೇಲೆ ಅಲ್ಲಿಲ್ಲ ಇಲ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ, ಅಲ್ಲೋ ಬಿಟ್ಟಿದ್ದೀನಿ ಇಲ್ಲೋ ಬಿಟ್ಟಿದ್ದೀನಿ ಅಂತ. ಅದಕ್ಕೆ ಥ್ರೂ ಹೋಮ್ ಸೆಕ್ರೆಟರಿ ರಿಲೀಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 11/4. ಆರ್ಡರ್ ಮಾಡೋದ್ ಮಾಡೋಣ, ಬಟ್ ಅವ್ರಿಗೆಲ್ಲ ಬುದ್ಧಿ ಕಲ್ಸ್ಬೇಡ. ಯಾಕೆ ಅಂತ ಹೇಳಿದ್ರೆ ಇಲ್ಲೂ ಮಾಡೋದು ಅಲ್ಲೂ ಮಾಡೋದು ಇವೆಲ್ಲ ನಿಲ್ಲಿಸ್ಬಿಡ್ಬೇಕು. ಸೆಕ್ಯೂರ್ಡ್ ಫ್ರಮ್ ಆಂಧ್ರ ಪ್ರದೇಶ್ ಇವರೇ ರೆಸ್ಕ್ಯೂ ಮಾಡಿದ್ದಾರೆ. ಅದಾದ್ಮೇಲೆ ಏನೋ ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆ ಹುಡುಗಿ ಕೊಡ್ತಾಳೆ, ಅದೇನು ಆಗ್ತಿತ್ತು ಅವ್ರಿಗೆ ಬಿಡ್ತಿತ್ತು, 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಇತ್ತು ಬಿಡ್ತಿತ್ತು. ಇವ್ರಿಗೇನು ಅವಸರ 30,000 ಇಲ್ಲ ಅಂತ ಹೇಳೋದಕ್ಕೆ? ಸೇಮ್ ಡೇ ಇನ್ನೂ ವರ್ಸ್ಟ್, ಅದ್ರ ಮೇಲೆ ನೋಡಿ ಸೈನ್ ಬೇರೆ ತಗೊಂಡಿದ್ದಾರೆ. 161 ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಸೈನ್ ಯಾರು ತಗೊಳ್ಬೇಕಂತೆ, ಅದು ಇನ್ಸ್ಪೆಕ್ಟರ್ ಬೇರೆ. ಏನೋ ನೆನ್ನೆ ಬಂದಿರೋ ಹೆಡ್ ಕಾನ್ಸ್ಟೇಬಲ್ ಅಲ್ಲ, ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್. ಒಕ್ಸೋ ಮ್ಯಾಟರ್ ನಲ್ಲೂ ಕೂಡ ಅವರು ಅಷ್ಟು ಎಕ್ಸರ್ಸೈಸ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಏನರ್ಥ? ಅಂಡ್ ಅವರ್ ದೇ ಟು ಇಂಟರ್ಫಿಯರ್ nullifying the statement made under 164. ಒಂದ್ ವೇಳೆ ಆಗಿತ್ತು ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, ಮಾನ್ಯ ದಿನ ಪುನಃ ಹೋಗ್ಬೇಕು, ಹೆಚ್ಚುವರಿ ಹೇಳಿಕೆ ಅಂತ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮುಂದೆನೆ ಕೊಡ್ಬೇಕು. ನೆನ್ನೆ ದಿವಸ ಹಿಂಗ ಆಗೋಗ್ಬಿಟ್ಟಿತ್ತು ಸ್ವಾಮಿ, ಹಂಗಾಗ್ಲಿಲ್ಲ, 30,000 ಬಗ್ಗೆ ಏನು ಗಲಾಟೆ ಇಲ್ಲ ನಮ್ದು, ಅದು ಬಿಟ್ಬಿಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ ಮುಗ್ದೋಗ್ತಿತ್ತು. ಅದು ಬಿಟ್ಬಿಟ್ಟು 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ನಾನು ನಲಿಫೈ ಮಾಡ್ತೀನಿ ಬೈ ಟೇಕಿಂಗ್ ಎ ಫರ್ದರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂತಂದ್ರೆ ವಾಟ್ ಇಸ್ ದಿ ಫನ್? ವಿಲ್ ಆರ್ಡರ್ ಫಾರ್ ಸಸ್ಪೆನ್ಷನ್ ಅಂಡ್ ಆಲ್ಸೋ ರಿಜಿಸ್ಟರ್ ಕಂಟೆಂಪ್ಟ್. ಮಾಡಿದ್ರೆಲ್ಲ ಒಬ್ಬರಿಗೆ ಮಾಡಿಬಿಟ್ರೆ ಇಡೀ ರಾಜ್ಯ ಸರಿ ಹೊಟ್ಟೋಡು. ಅರ್ಥವಾಯ್ತಾ ನಿಮ್ಗೆ? How can they do that? Yes. Yes, 46. Yes, please. Victim age 24 years. ಅದೇನದನ್ನ ಕಂಪ್ಯೂಟರ್ ಮೊಬೈಲ್ ಎಲ್ಲ ಇದೆ. ಓ, ಇದು ಇನ್ಸ್ಟಾಗ್ರಾಮ್. File your objections, mister. It's a case of blackmailing by taking a videograph. Learned HGP to file objections, release this matter on 12/4. Why Lakshmikant Rao?
Millets, I appear for petitioner Millets.
Yes.
Millets, the offense alleged is under section 307, please, Millets. Accused number 1 alleged to have assaulted the complainant. Whereas the role of this petitioner, he is accused number 2, Millets. At page 19 of my petition, Millets. In the remand application, after 7 lines, page 19, please, Millets, of the remand application, it is stated, ದಿನಾಂಕ 4/2/2022 ರಾತ್ರಿ 8 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಫಿರ್ಯಾದುದಾರರನ್ನು ಮತ್ತು ಪ್ರವೀಣ್ ರವರನ್ನು ಅಡ್ಡಗಟ್ಟಿ ವಾಸಿಂ, ಅಕ್ಯೂಸ್ ನಂಬರ್ 1, ಈತನು ಲಾಂಗ್ ನಿಂದ ಫಿರ್ಯಾದುದಾರರ ಬಲಗೈನ ಮೊಣಕೈಗೆ, ಎಡಕಿವಿಗೆ ಹಾಗೂ ಅರುಣ ಅಲಿಯಾಸ್ ಕಪ್ಪೆ ಈತನು ಮಚ್ಚಿನಿಂದ ಕಮಲ್ನ ಎಡಗೈ ಬೆರಳುಗಳಿಗೆ ಹಾಗೂ ಅದೇ ಮಚ್ಚಿನ ಮೂತಿಯ ತುದಿಯಿಂದ ಕತ್ತಿನ ಭಾಗಕ್ಕೆ ಚುಚ್ಚುತ್ತಾನೆಂದು ಬಿಡಿಸಲು ಹೋದ ಪ್ರವೀಣ್ ಕುಮಾರ್ ಅವರಿಗೆ ವಾಸಿಂ ಈತನು ಲಾಂಗ್ ನಿಂದ ಕತ್ತಿನ ಹಿಂಬದಿಗೆ ಹೊಡೆದು ಪ್ರಾಣಾಂತಿಕ ಹಲ್ಲೆ ಮಾಡಿ ಕೊಲೆಗೆ ಪ್ರಯತ್ನ ಪಟ್ಟಿರುತ್ತಾನೆಂದು. ಈ ಸಮಯದಲ್ಲಿ ರಾಕೇಶ್ ಮಿಲ್ಲಟ್ಸ್, ದಿಸ್ ಪಿಟಿಷನರ್, ಮತ್ತು ಮೌಲಾ ಇವರುಗಳು ಫಿರ್ಯಾದುದಾರರು ಮತ್ತು ಪ್ರವೀಣ್ ಕುಮಾರ್ ಇವರುಗಳು ಓಡಿ ಹೋಗದಂತೆ ಹಿಂಬದಿಯಲ್ಲಿ ಸುತ್ತುವರೆದು ನಿಂತಿದ್ದರೆಂದು ಹೇಳಿಕೆಯನ್ನು ತಿಳಿದು ಬಂದಿರುತ್ತದೆ. They were standing behind Millets, no overtax, nothing is recorded at the instance of the accused. The petitioner is aged about 21 years.
Why should he continue? Why should continue? ಕೊಡಿ ಡೀಟೇಲ್ಸ್ ಕೊಡಿ. ಕ್ರಿಮಿನಲ್ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ಇದೆಯಂತೆ ನೋಡಿ, ಇನ್ನ 4 ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಇದೆಯಂತೆ.
ಅಲ್ಲ, ಈ ಕೇಸಲ್ಲಿ absolutely there is no overtax, Millets.
What about the criminal antecedents? Have you stated in your petition?
Millets,
I have stated in your petition that I have been falsely implicated in other cases and I have been enlarged in bail in all those cases ಅಂತ ಹೇಳಿದಿರಿ.
ಅಲ್ಲ, ಅದರ್ ಕೇಸಸ್ ಐ ಆಮ್ ನಾಟ್ ಅವೇರ್ ಆಫ್ ದಿ ಅದರ್ ಕೇಸಸ್.
ಈಗ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನೋಡಿ, ಇನ್ನ 4 ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಇದೆಯಂತೆ. Yes.
As far as accused number 2,
you want to find out by afternoon or you want adjournment?
Monday, Millets, Monday.
Not Monday, next Monday, 11/4.
11/4. Please.
HCGP to file objections, 11/4. ಕೃಷ್ಣೇಗೌಡರು
ಏನ್ ಕೇಸ್ ಎರಡು ಇದೆಯಾ? ಓಕೆ.
ಎಸ್, ಕೃಷ್ಣೇಗೌಡ ಪಾಸ್ ಓವರ್. ಇದು ಓದ್ಸತ್ತಿನ ಬಂದಿತ್ತು ನೋಡಿ, ಅವ್ರು ಬಂದಿಲ್ಲ. ಹನುಮಂತರಾಯ,
I have not received the copy. Even I have not copy serve ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಅವರು. 2 days
ಏನ್
time.
ಕಾಪಿ ಇವ್ರೆ?
Assistants ಗೆ ಈಗ ಇದು ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ sir.
All right, that will come to it later. For what purpose?
Not well also, my lord. I have 2 weeks time.
Want to aid the prosecution? No, wait. Let him first convince. Yes, you convince the case. If it is necessary, ಅವಾಗ ಅವ್ರನ್ನ ಕೇಳೋಣ.
I am also not keeping well, my lord. Next week.
ಮತ್ ಅದ್ ಹೇಳಿ, ಅದ್ ಬಿಟ್ಬಿಟ್ಟು ಕಾಪಿ ಕತೆ ಯಾಕೆ ಹೇಳ್ತೀರಿ? ಹೋದ್ಸತಿನೂ ಬಂದಿತ್ತಲ್ಲ ಇದು. ಹೋದ್ಸತಿನೂ ಬಂದಿತ್ತು, ತಾವ್ ಬರ್ಲಿಲ್ಲ ಅಂತ ಅರ್ಜೆಂಟ್ ಮಾಡಿದೀನಿ.
Okay.
ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ ಮತ್ತೆ ಯಾಕೆ ಕೊಡ್ಬೇಕು?
Short
ಪದೇ ಪದೇ ಇದನ್ನೇ ಆಗತ್ತಲ್ಲ. ಅಪ್ರಹೆನ್ಷನ್ ಎಲ್ಲಿದೆ?
next week, my lord.
Hanmantaraya D, that counsel for the petitioner seeks time on the ground of his ill health. In the meantime, de facto complainant to serve a copy of his application IA 1 of 2022 to the counsel for petitioner release this matter on 12/4. Yes, Vishnumurthy. Let the charge sheet be filed. ಇದೆ ನೀವಿಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಡಿ. ಸುಮ್ನೆ ಯಾಕೆ ಪೆಟ್ರೋಲ್ ಎರಚಿ ಬೆಂಕಿ ಹಚ್ತಾರೆ? If you want to renew the after charge sheet, well and good. If you want an order, court will pass orders today. Yes, at request of Vishnumurthy, released on 12/4. 12/4. ಅದೇನೋ ಬೆಳಗ್ಗೆ ಏನೋ ಕೇಳಿದ್ರು ನೋಡಿ, ಒಬ್ಬರ ಮೇಲೆ ವಜಾ ಆಗಿದೆ, ಇನ್ನೊಂದು ಮೇಲೆ ಏನದು ನೋಡಿ, ಏನದು ಒಬ್ಬರ ಮೇಲೆ ವಜಾ ಆಗಿದೆ ಅಂತ. ಯಾರು? ಯಾವ್ದ್ರಲ್ಲಿ? ಆಗ್ಲಿ ಬಿಡಿ, ಇಲ್ದಾರೆ. ಇಫ್ ಯು ವಾಂಟ್ ಅನ್ ಆರ್ಡರ್, ಐ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್ ಟುಡೇ. ಪೆಟ್ರೋಲ್ ಹಚ್ಚಿ ಬೆಂಕಿ ಹಚ್ಚಿದಿರಿ, ಅದ್ರಲ್ಲೇನು ತೋರ್ಸೋದಿಕ್ಕಿದೆ? ಇವ್ರದ್ದೇನ್ ರೋಲ್ ಇರುತ್ತೆ ಅಲ್ಲಿ? ಯಾತಕ್ ಸುಮ್ನೆ ಒಬ್ಬರಿಗೆ? ಅದೆಲ್ಲ ಬರ್ಲಿ, 12th ನೋಡೋಣ. 12th ನೋಡೋಣ. ಏನಿದು? ಮೆಮೋ ವಿತ್ಡ್ರಾಯಲ್ ಆಫ್ ಪೆಟಿಷನರ್ ಆಯ್ತಲ್ಲ, ಇದು ಮುಗಿತಲ್ಲ, ಇದು ಸುರಂಗಿನಿ. ಎಸ್, ಯಾವ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟ್ರು? ನಟರಾಜು, ನೀವು ರೆಡಿ ಇದ್ದೀರಾ? ಕೌನ್ಸಿಲ್ ಫಾರ್ ಪೆಟಿಷನರ್ Tejas N absent. In the connected matter, counsel seeks time, released on 12/4. Narayana Swami, Pastor Bandari, ಬನ್ನಿ. ಹೇಳಿ. Yes. Yes. And also on the beer, with the beer bottle. ಎಲ್ಲಿದೆ? Where is the material? They have taken treatment from 25(1) to 2(2). Where it is stated as simple injury. No, where it is stated that it's simple injury. Yes. Medication ಇದೆ, ಮೆಡಿಕೇಶನ್ ಏನ್ ಕೊಟ್ಟಿದಾರೋ ಅವರು. That's okay, but the question is, what is the injury? Nature of injury ಎಲ್ಲಿದೆ? He has taken treatment for about 1 full week. If it is simple, why 1 full week? Same day, okay. Yes, what is the part chosen? ಕಪಾಳಕ್ಕೆ ಹೊಡೆದರು. ಆ ಸಮಯದಲ್ಲಿ ಕೊಲೆ ಮಾಡೋದನ್ನ ಬೀರ್ ಬಾಟ್ಲಿಂದ ತೆಗೆದುಕೊಂಡು ಹಣೆಗೆ ಹೊಡೆದು ರಕ್ತ ಗಾಯಪಡಿಸಿದನು. ಬಲಪಕ್ಕಕ್ಕೆ ಬಲಪುಚ್ಚಕ್ಕೆ ಭುಜಕ್ಕೆ ಚುಚ್ಚಿ ರಕ್ತ ಗಾಯಪಡಿಸಿದನು. ರಮೇಶ್ ಹಾಗೂ ಪ್ರಶಂಸಿಸಿ ಬೈಕ್ನಲ್ಲಿ ಹರಿಹರ ಆಸ್ಪತ್ರೆ ಕರ್ಕೊಂಡು ಹೋದರು. ಎಸ್, ಯಾವ ಅಸಾಲ್ಟೆಡ್ ವಿತ್ ಎ ಬೀರ್ ಬಾಟಲ್. ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಮಿಸ್ಟರ್. ಅವ್ರೇನೋ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ, 1 full week ತೆಗೆದುಕೊಂಡಿದ್ದಾರೆ, ಪಕ್ಕೆ ಇಕ್ಕೆಗೆಲ್ಲ ಚುಚ್ಚಿದ್ದಾರೆ. Release this matter on 12/4. In the meantime, CGP to file objections. Jagadisha. $53. ಏನಾಯ್ತದು? ಪಾಸ್ ಓವರ್ ಆಯ್ತಲ್ಲ, ಕರೆದ್ವಲ್ಲ. ಹೇಳಿ, ಈಗಲೇ ಹೇಳಿ ಏನಂತ. ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನು? ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ನೇಪಾಳಿ ಅಂತ ಇರುವ ವ್ಯಕ್ತಿಯೊಬ್ಬನ ಬ್ಯಾಗ್ ಒಂದನಿಗೆ ಹೆಗಲಿ ಹಾಕೊಂಡು ನೇತು ಹಾಕೊಂಡು ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಕಡೆ ಫ್ಲೈಓವರ್ ಕೆಳಭಾಗದಲ್ಲಿ ನಡೆದುಕೊಂಡು ಹೋಗುತ್ತಿದ್ದಾಗ 4 ಜನ ಆಸಾಮಿಗಳು ಹೋಗಿ ಮಾತನಾಡುತ್ತಿದ್ರು. ಸಿಬ್ಬಂದಿ ವಶಕ್ಕೆ ಪಡೆದು ಆಸಾಮಿಗಳ ಹೆಸರುಗಳನ್ನು ಕೇಳಲಾಗಿ, ಬಿನಯ್, ನಿಮ್ಮವನ್ ಯಾರು? ಪಾಪಿರೆಡ್ಡಿ. ಬಿನೋಯ್. ಅದಾದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಯಾರು? ಲಕ್ಷ್ಮಯ್ಯ, ಪಾಪಿರೆಡ್ಡಿ, ಆದಿಲ್ ಖಾನ್. ಎಲ್ಲಾರು ಒಪ್ಕೊಂಡಿದ್ದು ಚಿಂತಾಮಣಿ ಕರಲಿ ಅವರ ಗಿರಾಕಿಗಳ ನೀವು ತಗೊಂಡೋಗಿ ಅವ್ರ ಹತ್ರ ಇಸ್ಕೊಂಡೋಗಿ ಮಾರಾಟ ಮಾಡ್ತೀರಂತೆ. Yes, you file objections. File objections. ಏನೇ ಆಗ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ NDPS ಅಲ್ಲೆಲ್ಲ ಅಷ್ಟು ಸ್ಪೀಡ್ ಆಗಿ ಮಾಡೋ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ. ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್. 12/4. ಬುಧವಾರ ಅಂದ್ರೆ 12/4 ಅಲ್ಲ, ಮಂಗಳವಾರ 12/4, 13/4 ಬುಧವಾರ 13/4. ಎಷ್ಟು ಮೊಬೈಲು? ಎಷ್ಟು ಮೊಬೈಲ್ ಹ್ಯಾಂಡ್ ಸೆಟ್ಟು? ಒಂದ್ ನಿಮಿಷ ಚೆಕ್ ಮಾಡಲಾಗಿ ಅವರ ಬಳಿ ವಿವೋ ಕಂಪನಿ ಮತ್ತು ರೆಡ್ಮಿ ಕಂಪನಿಯ 2 ಮೊಬೈಲ್ಗಳು ದೊರೆತಿತ್ತು. ಒಟ್ಟು 4. ಮಹಿಳೆ ಠಾಣೆಗೆ ಬಂದು ದೂರು ನೀಡಿದ್ರೆ ಸದರಿ ಮಹಿಳೆ ದೂರು ನೀಡಲು ವಿಳಾಸ ಬಗ್ಗೆ ನಿರಾಕರಿಸಿದ ನಾವು ಅದರಿ ಹೆಚ್ಚಿನ ವಿಚಾರಣೆಗಾಗಿ ಸುಜುಕಿ ಆಕ್ಸೆಸ್ ವಾಹನವನ್ನು ಹೊಯ್ಸಳ ವೃತ್ತದಲ್ಲಿ ಸಂಜೆ 6 ಗಂಟೆ PSI ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ವರದಿಯನ್ನು ನೀಡಿರುತ್ತೇನೆ. ಎಸ್, 4 ಮೊಬೈಲ್ ನೀವು ತಗೊಂಡಿದ್ರೇನು? All right, where do you get that? Read page 20. ತನಿಖಾ ಕಾಲದಲ್ಲಿ 7/2/22 1ನೇ ಆರೋಪಿಯನ್ನು ಸಿಬ್ಬಂದಿಯವರು ಸುರಕ್ಷಿತ ಬೆಂಗಾವಲಿನಲ್ಲಿ ಕಳಿಸಿಕೊಟ್ಟು ತಪಾಸಣೆ ಮಾಡಿತ್ತು. A3 ಆರೋಪಿ ಸ್ವೇಚ್ಛಾ ಹೇಳಿಕೆಯನ್ನು ಕೊಟ್ಟಿದ್ದು, ನೀವು A3ನಾ? ಸ್ವೇಚ್ಛಾ ಹೇಳಿಕೆಯನ್ನು ಕೊಟ್ಟಿದ್ದು ಪಂಚರಿಗೆ ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ಮಾಲ್ಗಳನ್ನು ಜಪ್ತಿ ಮಾಡ್ಕೊಂಡು ಬರಲು ಸಿಬ್ಬಂದಿ ಪಂಚರನ್ನು ಕರೆಸಿ A3 ಆರೋಪಿ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಒಟ್ಟು 82 ಮೊಬೈಲ್ ಟೆಲಿಫೋನ್ ಸೆಟ್. ಅದಕ್ಕೆ ಕೇಳಿದ್ ನಾನು, ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿತ್ತಲ್ಲ ಸೇಮ್ ಮ್ಯಾಟ್. 82 ಮೊಬೈಲ್ ಹ್ಯಾಂಡ್ ಸೆಟ್. ಆರ್ ಯು ಮೊಬೈಲ್ ಡೀಲರ್? ಅರೆ ಎಸ್, ಚಾರ್ಜ್ ಶೀಟ್ ಆಗ್ಲಿ ಬಿಡಿ, ಬರ್ಕೊಳ್ಳಿ. ಹಾರ್ಡ್ ಶ್ರೀ ಜಗದೀಶ H, ಲ್ಯಾಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಪಿಟಿಷನರ್. ಪುಸ್ತಕ and learned HGP. First, next present petition is filed under section 439 CRPC with the following prayer. First, brief facts of the case are as under. Yes, memo kodu. After hearing for some time, Sri Jagdish H files a memo. Memo reads as under. You know the memo. Petition is dismissed as withdrawn with liberty as prayed for. Shiv Prasad. Yes, please. Yes, please. ಅದೇ fake marks card. You gave a helping hand. File objections, Mister. Whether you are involved in any other cases also. Yes. Yes. File objections. If he is a solitary case and he is a how helping hand, you should establish. Yes. Pass over. 12-4. 12-4. Objections. R.B. Deshpande.
I appear for the petitioner, my lord.
Heli Deshpande avare.
Application under 438, my lord.
Ah.
The offences alleged are 323, 324, 419, 406, 420 and 506, my lord.
What is the amount of misappropriation?
There is no misappropriation, my lord. This is that.
ಅದೇ ಪೊಲೀಸ್ ಡ್ರೆಸ್.
ಪೊಲೀಸ್ ಇದರಲ್ಲಿ ಬಂದು
ಪೊಲೀಸ್ ಡ್ರೆಸ್ ಹಾಕೊಂಡು ನಕಲಿ ಪೊಲೀಸ್ ಆಗಿ ದುಡ್ಡು ವಸೂಲಿ ಮಾಡೋದು. ಎಷ್ಟು ದುಡ್ಡು ವಸೂಲಿ ಮಾಡಿದ್ದಾರೆ?
ಅದು ನಾವು ಕೇಳಿದ 5 ಲಕ್ಷ, 4.5 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾನೆ.
50,000 ಕಮ್ಮಿ ಕೊಟ್ಟು. Yes, Mister. Admittedly fake police. Let them appear before the real police. Okay. Let them join the investigation. Let them join the investigation. Same day custodial investigation be completed.
Please, my lord. Please.
Yes, Barkoli heard Sri R.B. Deshpande and learned HGP. The present petition is under section 438 CRPC with the following prayer. First, next para brief facts of the case are as under. Avinash M.M., son of Madegowda, lodged a complaint with Chitradurga police.
Chitradurga Kote police, my lord.
Chitradurga Kote police.
Yes,
On 28/12/2021, which came to be registered in crime number 169 of 2021 for the following offences. Full stop. Page number 10. Next para. In the complaint, it is contended that on 20th October
2020.
ಅಲ್ಲ ಅಕ್ಟೋಬರ್ 2097 ತಾರೀಕು ನಂದು ಅಂದ್ರೆ ಹಂಗೆ
ಅಲ್ಲ ನಾವು ಕಂಪ್ಲೇಂಟ್ ಇದೆ ಪ್ರೊಡ್ಯೂಸ್
ಕರೆಕ್ಟ್. ಬಟ್ ಅದನ್ನ 97 ಹೆಂಗಾಗತ್ತೆ? 17 ಅದು.
ಅದೇ ತಪ್ಪಾಗಿ ಟೈಪ್ ಮಾಡಿ.
ಏನ 97 ಆಗ್ಬಿಟ್ಟಿದೆ ಅದು.
ಹೌದು.
ನನಗೆ ಸಂಬಂಧಿಕ ಮೂಲಕ ಪರಿಚಯ ಅಕ್ಟೋಬರ್ 20 ಅಕ್ಟೋಬರ್ 2020 ಅದು 17ನೇ ತಾರೀಕು. Complaint in the complaint it is contended that he is acquainted with Umesh and he is acquainted with one Srinivasa alias Sina through his relative Umesh of Kerpet. First, on 17th October 2020, Umesh and Sina called him to Nagamangala Devasthana, Nagamangala temple. First, therein ಇನ್ನೊಂದು ಯಾವ್ದೋ ಬಂದಿತ್ತಲ್ಲ, ಇದು ಅದೇ ತರದ್ದೇ 3 ಪಟ್ ಮಾಡುವಂಥದ್ದು. ಇದು ಅದೇ ತರದ್ದೇ. ಎಲ್ಲ ಚಿತ್ರದುರ್ಗದವ್ರೆ ಯಾಕೆ ಅದಕ್ಕೆ ಸಿಕ್ಕಾಕೋತಾರೆ ಅಂತ ತುಂಬಾ ಜನ ಸಿಕ್ಕಾಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಇನ್ನೊಂದು ಕೇಸಲ್ಲೂ ಅದೇ ತರನೇ ಮೇಲ್ಗಡೆ ಒರಿಜಿನಲ್ ನೋಟು ಅಂತ.
ಇಲ್ಲಿ ಇದೆ. I have my colleague is there, my lord. He will pass on the order copy granted by your lordship.
ಎಕ್ಸಾಕ್ಟ್ಲಿ ಅವ್ರು ಪಾಸ್ ಅವ್ರದಿತ್ತಲ್ರಿ, ಅದೇ ಮ್ಯಾಟ್ರ್.
ಅದೇ
Yes. And told that money dribbling scheme, doubling alla idu, money dribbling scheme is available and therefore he was required to part away the amount. First, next para. Based on the thereafter, complainant came to know that he has been cheated. First, after registering the case, police are investigating the matter. First, next para. In respect of the co-accused, First, next para. The petitioner approached the district court for grant of anticipatory bail in series number 25 of 2022, which was dismissed by the Karnataka district judge by order dated 21st January 2022. Thereafter, petitioner is before this court. First, next para. 11 counsel Sri R.B. Deshpande reiterating the bail grounds, further contended that this court by order dated 10th March 2022 in criminal petition number 756 of 2022 granted anticipatory bail with conditions to the court and the present petitioner may also be given the same
Alla-
ground of parity.
ಬೇರೆ police station ಅದು. This is different police station.
All right. In respect of ಮತ್ ಬೇಡ ಬಿಡಿ ಇದನ್ನ ಯಾಕೆ ಬಿಟ್ಕೋಣ. I'll pass independently the order. Next para.
Please.
Reiterating the above grounds contended that the petitioner is ready to abide by the conditions and he is a law-abiding citizen and he has been falsely implicated in the case and sought for grant of anticipatory bail. First, next para. For controller and HCGP opposes the bail petition on the ground that the prima facie materials in the form of complaint and the case diary reveal that the custodial investigation of the petitioner is utmost necessary to unearth the truth in the incident and therefore sought for rejection of the bail. Peruse the material on record meticulously in the rival conditions of the parties. First, next para. Complaint governments reveal that the complaint has been duped by the petitioner and others in the guise of money dribbling scheme and complaint had to part away with huge sum of money. First, the material on record prima facie reveal that that the complaint has been cheated by the accused person. First, however, this court at this stage is not required to hold a mini trial to find out the merits or demerits of the case. Accordingly, to unearth the truth in the incident, custodial investigation of the petitioner is very much necessary. First, however, the right of the petitioner may also be protected while so doing. But accordingly, following order, without expressing much opinion on the merits of the matter, following order is passed. First, next for petitioner is petition allowed. Petitioner directed to appear before the investigation agency on 11th April 2022 at 10 a.m. First, the investigation officer is at liberty to take him to custody and complete the custodial investigation on the same day at before 7 p.m. First, thereafter enlarge the accused petitioner on bail and taking a bond in a sum of rupees 1 lakh with 2 sureties for the like sum. First, petitioner shall not directly or indirectly tamper the prosecution evidence or hamper the investigation process. Petitioner shall mark his attendance before the investigation agency every alternate Sunday between 10 a.m. to 2 p.m. till the final report is filed. Petitioner shall attend the court regularly. Petitioner shall not leave the jurisdiction of the Chitradurga district without prior permission. First, violation of any conditions would entitle the prosecution to seek for cancellation of the bail order accordingly. Yes.
Please.
ಹೇಳಿ ಲಕ್ಷ್ಮೀಕಾಂತ್ ಅವ್ರೆ. ಚಿಟ್ ಫಂಡ್ ಏನ್ ಮಾಡ್ರಿ ಚೀಟಿ ಹಣ ಎಲ್ಲ ಎಲ್ಲಾರ್ಗು ನಾಮ ಹಾಕ್ಬಿಟ್ಟಿದಲ್ಲ, ತುಂಬಾ ಹೋಗ್ಬಿಟ್ಟಿದಲ್ಲ. ಈ ಜನಕ್ಕೆ ಪಟಾಕಿ ಚೀಟಿ, ದೀಪಾವಳಿಗೆ ಒಂದು ಬೆಳ್ಳಿ ದೀಪ, ಇನ್ನೂ ಬುದ್ಧಿ ಬರೋದೇ ಇಲ್ಲ ಅಂತ ಕಾಣುತ್ತೆ ನಾಮ ಹಾಕಿಸ್ಕೊಳಕ್ಕೆ. Yes, Mr. Let him appear before the investigation. Regular bail or charge sheet agli bidu. Let him be there, sir. ಜನಗಳಿಗೆಲ್ಲ ನಾಮ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾನೆ, ಹೊರಗಡೆ ಬಂದು ಇನ್ನೊಂದಷ್ಟು ಜನಕ್ಕೆ ನಾಮ ಹಾಕಿ ಇಲ್ಲರ ದುಡ್ಡು ಕೊಡಿಸ್ಬಿಟ್ಟು ಅವರೇ ವಿಡ್ರಾ ಮಾಡ್ಕೋತಾರೆ. ಈಚೆಗೆ ಬಂದ್ಮೇಲೆ ಓಡಾಗ್ಬಿಡ್ತಾನ್ರಿ, ಸಿಗೋದಿಲ್ಲ. ನೀವು ಸರಿ ಕಾಶಿ ವಿಶ್ವನಾಥನ್ ದರ್ಶನಕ್ಕೆ ಅಂತ ಹೋಗ್ಬಿಟ್ಟು ಕಾವಿ ಹಾಕೊಂಡು ಕೂತ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ. ಯಾವ ಗೌರ್ಮೆಂಟ್ ಇಷ್ಟೊತ್ತಿಗೆ ಸಸ್ಪೆಂಡ್ ಆಗಿರ್ತಾನೆ. ನೀವು ಸರಿ ಅರ್ಧ ಜನ ಅಕ್ಯೂಸ್ LPC ಕೇಸಲ್ಲಿ ಇರೋರೆಲ್ಲಾರು ಕಾಶಿಗೋ ಬದ್ರಿಗೋ ಹರಿದ್ವಾರಕ್ಕೆ ಹೋಗ್ಬಿಟ್ರೆ ಹಿಂಗ್ ಮುಖ ಎತ್ ನೋಡ್ಬೇಕು ನಾವು, ಯಾವ್ದಾರು ಕೇಸಲ್ಲಿ ತಪ್ಸ್ಕೊಂಡ್ರ ಇವನು ಅಲ್ಲೇ ಇರ್ತಾರ ಅಷ್ಟೇ. ಅಲ್ಲಿ ಒಂದೊಂದು ಆಶ್ರಮದಲ್ಲಿ ಒಂದೊಂದ್ ದಿನ ಫ್ರೀ ಊಟ ಇರುತ್ತೆ, ಗೊತ್ತಾಯ್ತಲ್ಲ. ಹೆಸರು ಕಾವಿ ಡ್ರೆಸ್, ಒಂದು ಅಲ್ಯೂಮಿನಿಯಂ ಕ್ಯಾರಿಯರ್ ತಗೊಂಡ್ಬಂದ್ಬಿಟ್ಟಿರ್ತಾರೆ. ಜಗಳ ಆಯ್ತಾ, ನಾವ್ ಇಲ್ಲಿಂದ ಪುಣ್ಯ ಅಂತ ತಗೊಂಡೋಗೋದಕ್ಕೆಲ್ಲ ಮಾಡೋದಕ್ಕಲ್ಲಿ ಜಗಳ. ಆ ಬಿಟ್ ಫ್ರೀ ಊಟ ತಿನ್ನಕ್ ಜಗಳ. ಏನೇನ್ ಮಾಡ್ಬೇಕು ನೋಡಿದವರೆಲ್ಲ ಪಾಪ ಕಾವಿ ಹಾಕೊಂಡಿದ್ದಾರೆ ಅಂತಾರೆ, ಇಂಗ್ಲಿಷ್ ಹಿಂದಿನ ಮಾತಾಡಿದ್ರೆ 10 ರೂಪಾಯಿ ಹಾಕೋ ಕಡೆ 100 ರೂಪಾಯಿ ಹಾಕಿ. ಈಸಿ ಕೆಲಸ ತಾನೆ. ಲೆಟ್ ಹಿಮ್ ಫೈಲ್ ಚಾರ್ಜ್ ಶೀಟ್, ಅಷ್ಟೊತ್ತಿಗೆ ನೋಡೋಣ ಬೇಕಾದ್ರೆ. ಅದರ್ವೈಸ್ ಸದ್ಯಕ್ಕೆ ಕ್ಲೋಸ್ ಮಾಡಿರ್ತೀನಿ, ಆಮೇಲೆ ಹಾಕೊಳ್ಳಿ ಅಂತ ಬರೀ. ಅದಕ್ಕೆ release this matter on 13/4. In the meantime, HGP to file objection. Release on 13/4.
I
Yes,
appeal
Mr.
for the petitioner, my lord. Application under 438, my lord. The alleged offence, my lord, is under section 307 and 504, my lord. There is a quarrel going on between one Timmegowda and the present petitioner. It is alleged, my lord, that the complainant is one Rangaswamy. My lord, he went and pacified the quarrel. In the meanwhile, it is said, my lord, the present petitioner brought a knife and assaulted, my lord, the complainant.
Just let him file objection. Yes, file objection. There is a 3 inches deep injury into the node. Beneath the stomach, abdomen region ಇದೆ. There is a injury on the abdomen.
Please, my lord, but the
On the left eye and abdomen.
Please,
2
my lord,
blows are there.
So though,
We'll
though
see.
we have,
We'll
please,
see. Objections
please.
by 13/4.
please,
Kumara?
Type of petitioners, my lords.
Yes, please.
My lords, 436 and 429 offense, my lords. This is 438.
ಯಾರಿಗೆ ಬೆಂಕಿ ಹಚ್ಚಿದ್ರಿ?
ಆ ಪಕ್ಕದ ಮನೆಯವರು there was a dispute with regarding to the my lords ಇದು ಮನೆದು. ಬಟ್ my lords, I read the complaint, my lords. ನೋಡಿ ನಾವು ಐ ವಿಟ್ನೆಸ್ ಇದೆ, ನಾವು ನೋಡಿದ್ವಿ ಅವ್ರು ಬೆಂಕಿ ಹಾಕ್ಬಿಟ್ಟು ಹೋಗಿದ್ದು ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ಅದಾದ್ಮೇಲೆ ಬೆಂಕಿ ಬೆಳಗ್ಗೆ ಬಂದು ನೋಡದೆ ಸುಟ್ಟೋಗಿತ್ತು ಅಂತ. my lords, I read the complaint, my lords. Typed copy, page number 13, my lords.
Yes.
ಪಕ್ಕದ ಮನೆಯವರೇ, my lords. I read page number 13, typed copy, my lords.
Yes.
ವಿಷಯ ಏನೆಂದರೆ, ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿದ್ದು ನಮ್ಮ ಮನೆಯ ಹಿಂಭಾಗದಲ್ಲಿ ವಾಸವಾಗಿರುವ ಕೃಷ್ಣಯ್ಯ ಬಿನ್ ಸಣ್ಣಯ್ಯ ರವರ ಹೆಂಡತಿ ಶಿವಕುಮಾರಿ ಇಬ್ಬರು ಸಣ್ಣ ಪುಟ್ಟ ವಿಚಾರಕ್ಕೆ ವಿನಾಕಾರಣ ನನ್ನ ಮತ್ತು ನಮ್ಮ ತಾಯಿಯ ಜೊತೆ ಗಲಾಟೆ ಮಾಡಿಟ್ಟಿದ್ದರು. ದಿನಾಂಕ 13/2/2022 ಮಧ್ಯಾಹ್ನ ಸುಮಾರು 2 ಗಂಟೆಯ ಸಮಯದಲ್ಲಿ ನನ್ನ ಮತ್ತು ನಮ್ಮ ತಾಯಿಯ ಜೊತೆಯಲ್ಲಿ ಜಗಳ ಮಾಡಿದಾಗ ಗ್ರಾಮಸ್ಥರು ಇಬ್ಬರಿಗೂ ಸಮಾಧಾನಪಡಿಸಿ ಬುದ್ಧವಾದ ಹೇಳಿ ಕಳಿಸಿದರು. ನಂತರ ನಾನು ನಮ್ಮ ಅಕ್ಕನ ಮನೆಯಿಂದ ಮಾರನಹಳ್ಳಿಗೆ ಹೋಗಿ ರಾತ್ರಿ ಅಲ್ಲೇ ಇದ್ದಾಗ ಈ ದಿವಸ ದಿನಾಂಕ 14/2/2022 ಬೆಳಗ್ಗೆ 6:30 ಗಂಟೆಯಲ್ಲಿ ನಮ್ಮ ಯಾರಿಂದಲೋ ಫೋನ್ ಮಾಡಿಸಿ ನನ್ನ ದಿವಸ 19/2/2022 ರಾತ್ರಿ 12:30 ಗಂಟೆಯಲ್ಲಿ ನಮ್ಮ ಮನೆಗೆ ಹೊಂದಿಕೊಂಡಿರುವ
ಪ್ರೈವೇಟ್ ಇನ್ಸಿಡೆಂಟ್ ತೆಂಗಿನ ಗರಿಗೆ ಹಾಕಿದ್ದಾರೆ, ಬೆಂಕಿ ಹಚ್ಚಿದ್ದಾರೆ, ಹ್ಯಾಚಡ್ ರೂಫು. ಬರ್ಕೊಳ್ಳಿ. ಶ್ರೀ ಕುಮಾರ ಕೆಜಿ ಅಂಡ್ ಲರ್ನಡ್ HGP. Present petition is under section 438 CRPC with the following prayer. First, the brief facts of the case are as under. A complaint came to be lodged by Jaibora, son of Subaya, to Bilikere Police Station, Hunsur Taluk. In the complaint, it is contended that there was a dispute with Krishnaya and Shivkumari on trivial issues. First, and there was a ill will between the complainant and the family of Krishnaya. First, the quarrel were pacified by the elders of the village. First, when the matter stood thus, on 14/2/2022 at about 6:30 p.m., the mother of the complainant got telephone to the complaint to somebody. First, on 13/2/2022 at about 12:20 a.m., 12:30 a.m, the cowshed of the complainant, which had the hatched roof, was in a ablaze condition. First, when complainant got up and saw Krishnaya and Shivkumari were running away from the place of incident. First, neighbor Siddhaya, neighbor Chalva Santosha and Chandranna, neighbors Santosha and Chandranna extinguished the fire. First, the hatched roof was completely burned and a cow and calf had also sustained burn injuries. First, based on the said complaint, the Ilikere police registered a case in crime number 49 of 20 on 14/2/2022 for the offence punishable under section 436, 429, reduced section 34 IPC. After registering the case, police are investigating the matter. The petitioner is absconding from the date of petitioners are absconding from the date of incident, and they approached the district court for grant of bail, which was turned down by the additional district judge by order dated 25th February 2022 in series number 307 of 2022 on the ground that custodial investigation of the petitioner is utmost necessary in regard to the nature of the offence. Thereafter, the petitioners are before this court. Land counsel for the petitioner vehemently contended that there is a delayed complaint and the complaint is going to be lodged after due deliberation in order to take revenge on account of the ill will between the parties, and petitioners are nowhere responsible for the alleged incident and sought for grant of anticipatory bail. First, per control and HCP opposes the bail petition on the ground that the abscondence of the petitioners has resulted in crippling the investigation process, and therefore custodial investigation of the petitioners are utmost necessary to unearth the truth in the incident and sought for rejection of the bail. First, peruse the material on record meticulously in the rival contents of the parties. First, admittedly, from the complaint government itself, there is an ill will between the complainant family and the petitioners. First, on account of some trivial issues. First, according to the complainant governments, the complainant has seen the incident wherein the petitioners are after lighting the fire, were proceeding towards the house. First, incident occurred on 13/2/2022 at about 12:30 A.M. First, the complaint came to the lot on 14/2/2022 at about 1:15 P.M. First, next para. Further, the fire is also extinguished by the neighbors. First, if that were to be so, what made the petitioners complainant to immediately inform the incident to the police is a question that is to be investigated by the police after thorough investigation. First, suffice to say that the material on record at this stage would not disentitle the petitioners from obtaining an order of grant of anticipatory bail by resorting to the special powers vested in this court under section 438 CRPC. First, however, at the same time, need of the prosecution for custodial investigation cannot be lost sight of. Accordingly, following order is passed. First, petition allowed. Petitioners are directed to join the investigation by appearing before the investigation officer on 11/4/2022 at 10 a.m. The investigation officer is at liberty to take the petitioner to custody and complete the custodial investigation on the same day before 6 p.m. and thereafter enlarge the accused petitioners on bail by taking a bond in a sum of ₹50,000 each with 2 sureties for the like sum. First, a petitioner shall not leave the Mysore district without their permission, so and so. Violation of any conditions on.
Please.
Why? Sorry? Counsel for the petitioner seeks time released on 13/4. Yes, please.
The petitioner was arrested in pertaining to crime number 230 was applied. The petition was released on bail on that case. Thereafter, charge sheet is filed in this case.
ಅಬ್ಸ್ಕಾಂಡಿಂಗ್ ತೋರಿಸಿದಾರಲ್ಲ, ಅವತ್ ನೀವು ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದ್ರಾ? ಕರೆಕ್ಟು. ಈ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕೋ ಕಾಲಕ್ಕೆ ನೀವು ಇನ್ನೂ ಕಸ್ಟಡಿಯಲ್ಲೇ ಇದ್ರಾ ಅಂತ ಕೇಳಿದೆ. ಮತ್ತೆ Yes, let him appear before the court. Charge sheet is now filed. ಅದ್ರಲ್ಲಿ ಬೇಲ್ ಆದ್ಮೇಲೆ ನೀವು ಹುಡ್ಕೊಂಡು ಹಿಡ್ಕೋಬೇಕಾಗಿತ್ತು ಅಂತ. ನೀವು ಬಿಟ್ಬಿಟ್ಟಿದ್ದೀರಿ ನಮ್ನ, ಬಹಳ ಒಳ್ಳೆ ಕೆಲಸ ಮಾಡಿದಿರಿ, ಹಾಗಾಗಿ ನಮ್ಗೀಗ ನೀವು ನಿಮ್ ತಪ್ಪಿಗೋಸ್ಕರ ನಮಗ್ ಬೇಲ್ ಕೊಡಿ ಅಂತ. ದಟ್ ದಿ ಆರ್ಗ್ಯುಮೆಂಟ್. ಈಗ ಅಲ್ಲಿ ಅವ್ರದ್ದು ರಿಕವರಿ ಏನಿಲ್ವಾ ಇದ್ರಲ್ಲಿ? ಶ್ರೀ Abdul Rashid Sikandar Saab Kulkarni and learned HGP. First, the petition under section 438 CRPC with the following prayer. First, brief facts of the case are as under. Manoj Kumar TS lodged a complaint with DJ Halli Police Station on 9/9/2018. First, in the complaint, it is contended that when the complainant was on a morning walk at about 5:30 a.m. on 23/7/2018, at about 5:45 p.m., 3 persons came on a black colored motorcycle with their face covered with the helmets. And one person, three persons came on a black colored motorcycle, and one among them got down from the motorcycle and approached him and stood in front of him and took a long knife and threatened him. And thereafter, they snatched a neck chain under the neck, under the knife point. First, under the threat of knife point, first, police, after registering the case, were investigating the matter. First, in the meantime, petitioner herein was apprehended by the police in respect of crime number 464 of 2018 of Banaswadi Police Station for the offence punishable under section 399 and 402, first, and read with section 25(1)(b) of Arms Act. First, during the course of said investigation, DJ Halli Police, the investigation officer of that case, came to know that the gold chain recovered from the custody of the accused in pursuant to the accused statement, in pursuance of the voluntary statement given by the accused petitioner, found that the gold chain is in respect of the crime number 234 of 2018 of DJ Halli Police Station, and transferred the property, that is the gold chain, to the DJ Halli Police. First, after the petitioner has been enlarged on bail in respect of crime number 464 of 2018, the petitioner is shown as an absconding accused in crime number 234 of 2018 of DJ Halli Police. First, land counsel for the petitioner. First, thereafter, petitioner approached the district court for grant of anticipatory bail, which was turned down by order dated 11th October 2021 in series number 26-064 of 2021. First, land counsel for the petitioner vehemently contended that he is not at all aware of the pendency of crime number so and so, and is innocent of the offences alleged against him in respect of crime number 234 of so and so, and sought for grant of anticipatory bail. First, per contra, and HGP opposes the bail petition on the ground that petitioner is a habitual criminal, and therefore is not entitled for grant of anticipatory bail. He also opposed the bail grant of anticipatory bail on the ground that he has been shown as an absconding accused. Next para. In the light of the above rival contentions, this court perused the material on record. Admittedly, the accused petitioner was in custody in respect of crime number 464 of 2018 of Karnataka Police. So in the course of said investigation, a gold chain seized is made as the part of the crime number 234 of 2018 of DJRL PS, and absconding charge sheet came to be filed against the petitioner. Before enlarging the petitioner on bail in respect of 464 of 2018, the investigation of after enlarging the investigation officer of DJRL was required to arrest the petitioner. However, such a thing has not taken place, and an absconding charge sheet came to be filed. Taking note of the fact that an absconding charge sheet is filed and the investigation and trial has also not progressed, directing the petitioner to appear before the jurisdictional court in respect of crime number 234 of 2018 would meet the ends of justice. Since already recovery of the gold chain has taken place in respect of the crime number 234 of 18, custodial investigation of the petitioner is unnecessary. Accordingly, following orders for petition allowed, petitioner is directed to appear before the jurisdictional court in respect of crime number 234 of 18 on 11/4/2018. He shall file necessary application if the date of hearing is not on 11/4/2018 and appear before the court voluntarily. The petitioner if arrested be enlarged on bail by taking a bond in a sum of rupees 50,000. Investigation officer ಮುಂದೆ ಹೋಗ್ಬಿಟ್ಟು ಯಾವತ್ತಿದೆ ಅವತ್ತು ಹೋಗ್ತಾನೆ. ಕೋರ್ಟಲ್ ಯಾವತ್ತಿದೆ ನಮಗೆ ಗೊತ್ತಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಹೇಳಿದ್ರೆ ಅವತ್ತು ಹೋಗಿ petitioner shall appear before the DJRL police on 8/4/2022 at 10 a.m. Investigation officer on arrest of the petitioner shall enlarge him on bail on taking a bond in a sum of rupees 50,000 with 2 sureties for the like sum. Petitioner shall attend the court regularly. Petitioner shall not repeat similar offences. Petitioner shall mark his attendance every third Sunday till the trial in 234 of 2018, crime number 234 of 2018 is completed. Petitioner shall not directly or indirectly tamper the prosecution witnesses. Petitioner shall not leave the Bangalore district jurisdiction without prior permission. Violation of any one of the condition would entitle the prosecution to seek for cancellation of the bail. Yes, please. ಯಾವುದು 20 ಸರ್ವಿಸ್ ಆಗಿದೆ ಅವರ ಅಪೇರ್ ಆಗ್ಲಿ ಯಾವತ್ತಾರು ನಿನ್ನ ನಾವೇನ್ ಮಾಡಕ್ಕಾಗ್ತದೆ ನೀವು ಬರ್ದೇ ಇದ್ರೆ ಈಸ್ ಇನ್ ಕಸ್ಟಡಿ ಮ್ಯಾಟ್ರಿಸ್ ಫ್ರಮ್ 2021 ಆಲ್ ರೈಟ್ ಯು ಅಡ್ರೆಸ್ ಚಾರ್ಜ್ 2020 ಅವರು ನಾನು 3 ಸತಿ ಕೇಳಿ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೊಟ್ಬಿಟ್ಟು ನೀವು ಬರ್ಲಿಲ್ಲ ಅಂತ ಕೋರ್ಟ್ ನೋಟಿಸ್ ಮಾಡಿದ್ದೀನಿ. ಅದಾಯ್ತು, ನಾನು ಯಾವ್ದನ್ನು ಬೆಳಗ್ಗೆ 10:00 ಅಡ್ಜೆಂಟ್ ಮಾಡೋದಿಲ್ಲ, 4:00 ಆರ್ಡರ್ ಎಲ್ಲ ಮಾಡೋದು. ಬೆಳಗ್ಗೆಯಿಂದ 4:00 ತನಕ ಕಾದು ಯಾರು ಬರೋದಿಲ್ವೋ ಆವಾಗ ಇದನ್ನ ಮಾಡೋದು. ಇದಕ್ಕೆ 4 ಸತಿ ಅಡ್ಜೆಂಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ. Accused is in custody. His bail petition came to be filed in the year 2021. What to do? All right, you argue the matter. Subsequently remand ಎಲ್ಲ ಬಂದಿದೆ, ನಿಮ್ಮ ಹತ್ರನೂ ಸಿಕ್ಕಿದೆ. ಮತ್ತೆ ಇಂಟ್ರೊಡ್ಯೂಸ್ಡ್ ಅಲ್ಲ, ಐ ವಿಟ್ನೆಸಸ್ ಆರ್ ದೇರ್ ಫಾರ್ ದಿ ಕೇಸ್ ಅಷ್ಟೇ. ಎಸ್ ಬರ್ಕೊಳ್ಳಿ. ಹರ್ಡ್ ಸಿ so and so and learned HGP. Present petition is filed under section 439 CRPC with the following prayer. First, next para. Following prayer. First, next para. Three facts of the case are as under. First, a complaint came to be lodged by Suresh, son of Srinivas, of to Cottonpet Police on ಯಾವ ಡೇಟ್ ಇದು? on 7/2 7/2/2018. First, in the complaint it is contended, which was registered in crime number 27 of 2018 for the offence punishable under section 34, 302 and section 302 reduced section 34 IPC. First, in the complaint it is contended that the complainant is residing in ಇದು ಸ್ಪಿಟ್ ಅಪ್ ಇದು ರೆಗ್ಯುಲರ್ ಕಾರ್ಪೊರೇಟರ್ ಗಲಾಟೆ ತಾನೆ ಇದು ಅದೇ ತಾನೆ ಮತ್ತೆ ಮೂರನೇ ಸತಿ ಓದಿದ್ದಿ ಪೇಪರು ನೆಕ್ಸ್ಟ್ ಬರ ಆಯ್ತಾ ಕಂಪ್ಲೇಂಟ್ ಈಸ್ ವರ್ಕಿಂಗ್ ಆಸ್ ಎ ವರ್ಕಿಂಗ್ ಆಸ್ ಎ ಸೋಷಿಯಲ್ ಏನು ಇವನ್ ಯಾರು ಕಂಪ್ಲೇಂಟ್ ಏನಾಗಬೇಕು social worker and himself and his brother Kadresh himself and his sister-in-law Rekha are working as social workers in ward number 138. First, his sister-in-law is working as is elected as a corporator in respect of ward number 138. First, his elder brother Kadresh was also assisting his sister-in-law in her work. First, on the Shivratri festival, when they were near the Muneshwara temple for cleaning of the temple, on 7/2/2018 at about 7 AM, they had engaged 10 laborers for the purpose of cleaning the temple. At about 3:45 PM, his elder brother Kadresha received a phone call on his mobile telephone. First, immediately he reached the back side of the temple. At that juncture, Naveen, Vinay and two others came there armed with deadly weapons like iron rods and machete and with knife, and assaulted on the Kadresh, on the head of the Kadresh, and also on the neck region and abdomen region. First, immediately he rushed to the spot. First, however, the assailants had ran away from the spot. First, Dilip Appukutti, Rajkumar, Kumaresh and the complainant immediately shifted the Kadresh to Victoria Hospital. First, however, despite best treatment, she died at 4:10 PM. Accordingly, he sought for action. First, police, after registering the case, have investigated inter alia, arrested the petitioner. First, arrested the petitioner. First, ಯಾವತ್ತು ನಿಮ್ಮನ್ನು ನಡೆಸಿದ್ದು 22/2/2018. First, the petitioner approached the district court for grant of bail in series number 64 of 32 of 2021, which was rejected by the learned special judge by order dated 12th November 2021. First, the police, after thorough investigation, filed charge sheet against the petitioners herein for the following offences. ನೋಡಿ 302 ಜೊತೆಗೆ ಇದು ಹಾಕೊಂಡು NDPS ಹಾಕೊಳ್ಳಿ, ಗೊತ್ತಾಯ್ತಲ್ಲ, ಎಲ್ಲ ಹಾಕೊಳ್ಳಿ, ಹಾಕೊಂಡು ಅದು ಇಟ್ಕೊಳ್ಳಿ, ಆಯ್ತಾ. ಆಮೇಲೆ NDPS so and so. First, thereafter petitioner is before this court with the prayer for grant of bail. First, learned counsel for the petitioner reiterating the bail grounds, contended that the petitioner is innocent of the offences alleged against him and he has been falsely implicated by political influence, falsely implicated by the police under the political influence, and sought for grant of bail. First, net per control or HCGP opposes the bail petition, stating that ಅದು ಯಾವ್ದ್ರೇನಂತೆ ಇವ್ರ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಇದೆಯಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಪರ, he also contended that accused number 3 has been granted bail and therefore on the ground of parity, present petitioner is also entitled to be enlarged on bail. First, per control and HCP opposes the bail petition on the ground that the eyewitnesses are available who have spoken. In the charge sheet, there is a statement of the eyewitnesses recorded by the investigation agency who have specifically deposed, who have specifically stated about the individual court act of the present petitioner present petitioner as well and sought for rejection of the bail. First, next para peruse the material on record in the right of so and so. First, admittedly, comma, the case of the prosecution gets the support of the statements of the eyewitnesses in the incident. First, the eyewitnesses are specifically stated about the overt act of the present petitioner as well. First, the police, after thorough investigation based on the voluntary statement, recovered the deadly weapon in pursuance to the voluntary statement given by the present petitioner. First, material on record clearly shows that the deceased died a homicidal death on account of the assault received by him from the petitioner and others. First, this court at this stage cannot hold a mini trial so as to assess the merits and demerits of the case, as the same may prejudice the case of the parties during the trial, one way or the other. First, suffice to say that the material available on record would definitely disentitle the present petitioner from obtaining an order of grant of bail, at least at this stage. First, next para. Therefore, comma, this further apprehension expressed by the prosecution is well founded. Accordingly, comma, this court is of the considered opinion, no case is made out for grant of bail by resorting to the special powers vested in this court and section 439 CRPC. Hence, following order. Since the accused is in custody, trial may be trial court directed to expedite the trial. Hari Prasad. ಅಯ್ಯ ಇರ್ಲಿ ಮಾ, ನಿಮ್ ಕೇಸ್ ಏನ್ ಅದನ್ನ ಹೇಳಿ. ಅವ್ರಿಗೆ ಪರ್ಮಿಷನ್ ಕೊಡೋದು ಬಿಡೋದು ಕೋರ್ಟ್ಗೆ ಬಿಟ್ಟಿದ್ದು. ಯಾರೋ ಒಬ್ರು ಪ್ರಾಸಿಕ್ಯೂಟರ್ಗೆ ಅಸಿಸ್ಟೆನ್ಸ್ ಕೊಡ್ಬೇಕು ಅಂತ ಕೇಳ್ತಾರೆ, ಡಿಫ್ಯಾಕ್ಟೋ ಕಂಪ್ಲೇನೆಂಟು. ಅವ್ರು ಬೇಕಾದ್ರೆ ಕೊಡ್ಲಿ, ನಿಮ್ ಕೇಸ್ ಏನ್ ಹೇಳಿ. ಅವ್ರಿಗೆ ಪರ್ಮಿಷನ್ ಕೊಡೋದು ಬಿಡೋದು ಕೋರ್ಟ್ಗೆ ಬಿಟ್ಟಿದ್ದು. ಹೇಳಿದ ಅರ್ಥ ಆಯ್ತಲ್ಲ. 439 ನಲ್ಲಿ ಅವ್ರ ಪರ್ಮಿಷನ್ ಕೊಡೋದು ಬಿಡೋದು ನಮ್ಮ ಕೋರ್ಟ್ಗೆ ಬಿಟ್ಟಿದ್ದು. ಅವ್ರು ಸರಿಯಾಗಿ ಅಪೋಸ್ ಮಾಡದೆ ಹೋದ್ರೆ ಅವಾಗ ಅವ್ರ ಸಹಾಯ ಬೇಕಾಗುತ್ತೆ. ನಿಮ್ ಕೇಸ್ ಏನ್ ಹೇಳಿ. Kindly read the complaint at page number 16. Para 2. ನನ್ನ ಅಣ್ಣ ನಾಜೀರ್ ತರಕಾರಿ ಗೂಡ್ಸ್ ವಾಹನದ ಚಾಲಕನಾಗಿ, ಅಲ್ಲಿಂದ ಶುರು ಆಗುತ್ತೆ, ಓದಿ.
ತರಕಾರಿ ಗೂಡ್ಸ್ ವಾಹನದ ಡ್ರೈವರ್ ಆಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿಲ್ಲ. ಅವನಿಗೆ 37 ವರ್ಷ ಆಗಿತ್ತು. ಅಣ್ಣನಿಗೆ ಗೊತ್ತಾಗದಂತೆ ಅವರ ಹೆಂಡತಿ KRಪೇಟೆ ಮನೆ ಖಾಲಿ ಮಾಡಿ ಮಕ್ಕಳ ಜೊತೆ ಅಸ್ತಿಯಪಾಡು ಅವರು ತಾಯಿ ಮನೆಗೆ ಬಂದಿದ್ದರು. ನನ್ನ ಅಣ್ಣ ಡ್ರೈವಿಂಗ್ ಮಾಡಿಕೊಂಡು KRಪೇಟೆ ಗಾಡಿ ಹೋಗಿದ್ದರು. ಒಮ್ಮೊಮ್ಮೆ ಅಕ್ಕಿಯಪಾಡುವಿನಲ್ಲಿನ ವಾಸವಿರುವ ನಾನು, ನನ್ನ ತಮ್ಮ, ನನ್ನ ತಾಯಿಯವರು ಇದ್ದ ಕಡೆಗೆ ಬಂದು ಹೋಗಿದ್ದು. ಕೊನೆಯದಾಗಿ ಕಳೆದ ಈ ದಿನ ಮೊದಲ ದಿನ ಅಕ್ಕಿಯಪಾಡು ಮನೆಗೆ ಬಂದು ಹೋಗಿದ್ದು. ಈ ದಿನ ದಿನಾಂಕ 27/10/2021 7:30 ಗಂಟೆಗೆ ನಾನು ಮಿಡಿಕೆರೆಯಲ್ಲಿ ಇದ್ದಾಗ ನನಗೆ ನನ್ನ ಭಾವ ಎಜಾಜ್ ಪಾಷಾ ಅವರು ಫೋನ್ ಮಾಡಿ ಅಣ್ಣ ನಾಸಿಫ್ ಪಾಷಾ ಅವರನ್ನು ಸಿಂಗನಹಳ್ಳಿ ಹಜರತ್ ನಿಜಾಮುದ್ದೀನ್ ದರ್ಗದ ಬಳಿ ಕೊಲೆ ಮಾಡಿ ಹಾಕಿದ್ದಾರಂತೆ ಎಂದು ತಿಳಿಸಿದರು. ನಾನು ಇಲ್ಲಿ ಬಂದು ನೋಡಿರುತ್ತೇನೆ. ಈ ದರ್ಗದಲ್ಲಿ ಅಡುಗೆ ಮಾಡುವ ಶೀಟ್ ಹತ್ತಿರ ರೈಲ್ವೆ ಹಳ್ಳಿಗೆ ಆದಂತೆ ನನ್ನ ಅಣ್ಣನ ಶವ ಎಲ್ಲಿ ಬಲಿಯಾಗಿ ಬಿದ್ದಿರುತ್ತದೆ. ಮುಂಭಾಗ ಕುತ್ತಿಗೆ ಮುಗ ತಲೆಗೆ ಯಾವುದೋ ಆಯುಧದಿಂದ ಬಲವಾಗಿ ಹೊಡೆದು ಎಲ್ಲೋ ಕೊಲೆ ಮಾಡಿ ತಂದು ಹಾಕಿತ್ತು. ಪ್ರಯತ್ನ ಮಾಡಲು ಕಾಣಿಸಿದೆ. ದರ್ಗದ ಮುಂಭಾಗ ನೆಲದಲ್ಲಿ ಸುಮಾರು ರಕ್ತ ಹರಿದು ಬೇಲಿ ಹಾಕಿದ ಎಳೆದುಕೊಂಡು ಕಾಣುತ್ತದೆ. ಅಲ್ಲದೆ ಅಕ್ಕಿಯಪಾಡುವಿನ ದೊಡ್ಡರಗುಡಿ ಹತ್ತಿರ ಚಂದ್ರಮೋಹನ ಅಂಗಡಿಯ ಬಳಿ ರಕ್ತ ಹರಿದಿದೆ ಎಂದು, ಅಲ್ಲಿಂದ ಈ ದರ್ಗಕ್ಕೆ ಬರುವ ಸುಂದನಹಳ್ಳಿ ಕುರಿತು ಬರುವ ಕಣ್ಣು ರಸ್ತೆಯಲ್ಲೂ ರಕ್ತ ಬಿದ್ದಿರುವುದು ಕಂಡು ಬರುತ್ತಿದೆ. ದಿನಾಂಕ 26/10/2021 ರಾತ್ರಿ ವೇಳೆಯಲ್ಲಿ ಕೊಲೆ ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿದೆ. ನಾನು 8:30 AM ಬಂದು ನೋಡಿದ್ದೇನೆ. ನನ್ನ ಅಣ್ಣ ಮತ್ತು ಅತ್ತಿಗೆ ವಿರಸ ಇದ್ದ ಕಾರಣ ನನ್ನ ಅತ್ತಿಗೆ ಬೇರೆ ವ್ಯಕ್ತಿ ಜೊತೆ ಅಕ್ರಮ ಸಂಬಂಧ ಕೇಳಿಪಟ್ಟಿದ್ದೇನೆ. ನನ್ನ ಅಣ್ಣನನ್ನು ಕೊಲೆ ಮಾಡಿರುವವರ ಮೇಲೆ ಕಾನೂನು ರೀತಿ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಹೋಗಿದೆ. based upon the complaint, like to know the
ರಿಮಾಂಡ್ ಅಪ್ಲಿಕೇಶನ್ ಓದಿಮ್ಮ. ಬೆಳಗಿಂದ ಇದ್ದೀರಿ, ಬೇರೆ ಲಾಯರ್ಸ್ ಏನ್ ಕೇಳ್ತೀವಿ ಅಂತ ಕೇಳ್ಕೊತಾ ಇದ್ದೀರಿ, ನೋಡ್ಕೋಬೇಕು ತಾನೆ. ಎಸ್, ಯು ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಮಿಸ್ಟರ್ HGP to file objections. Release this matter on 13th April. Yes. What is this? Folks Act. Yes, please. What is the age of the victim girl?
The complaint says it is return complaint. 14 years.
Yes.
No, 16 years. Thereafter, he changes it to 14 years.
All right, no problem. 14 or 16 or less than 18 tane.
Yes. But my humble submission to this honorable committee is there are so many gaping holes. These contradictions between the complaint, between amendments in the complaint and the victim girl before the PS Act on 23/8/21.
Those are all for Chandrasekhar, those are all for the child. We are at the bail stage. 164 statement is page number 28, relevant portion.
I will read it.
Page number 28, relevant portion. In page number 28, 19, 18, ಅದು 2-3 ನಂಬರ್ಗಳಿದೆ. ನೀವು 27 ಅಂತನಾರ ಅನ್ಕೊಳ್ಳಿ, 18 ಅಂತನಾರ ಅನ್ಕೊಳ್ಳಿ. Victim girl name is 27 ಆಗುತ್ತೆ. ರೆಲೆವೆಂಟ್ ಪೇಜ್ ಇಸ್ 28. ನಾನು ಮಾರಗೊಂಡನ ಹಳ್ಳಿಯಲ್ಲಿ ತಂದೆ ತಾಯಿಯೊಂದಿಗೆ ವಾಸವಾಗಿರುತ್ತೇನೆ.
ನಾವು ಮಾರಗೊಂಡನಹಳ್ಳಿಯಲ್ಲಿ ತಂದೆ ತಾಯಿಯೊಂದಿಗೆ ವಾಸವಾಗಿರುತ್ತೇನೆ. ನಾನು SSLC ಓದುತ್ತೇನೆ. ನನಗೆ ಮದುವೆ ಮಾಡಬೇಕೆಂದು ನನ್ನ ತಂದೆ ತಾಯಿ ಮಾತನಾಡಿದರು. ನನಗೆ ಈಗಲೇ ಮದುವೆ ಮಾಡಿಕೊಳ್ಳಲು ಇಷ್ಟವಿರಲಿಲ್ಲ. ಚಿಕ್ಕ ಬ್ಯಾಗದ ಬಳ್ಳಿ ಗ್ರಾಮದ ವಿಜಯ ಎಂಬ 1 ವರ್ಷದಿಂದ ಪ್ರೀತಿ ಮಾಡಿದ ಆತ JCB ಡ್ರೈವರ್ ಇರುತ್ತಾನೆ. ನಾನು ದಿನಾಂಕ 22/8/2021 ನನ್ನ ತಾಯಿ ಮನೆಯಲ್ಲಿ ಸಂಜೆ ಸುಮಾರು 4 ಗಂಟೆಯ ವೇಳೆಯಲ್ಲಿ ನಾನು ನನ್ನ ತಾಯಿಗೆ ಗೊತ್ತಾಗದಂತೆ ಅಲ್ಲಿಂದ ಹಾಸನದ ಬಸ್ ನಿಲ್ದಾಣಕ್ಕೆ ಹೋದೆ. ಬಸ್ ನಿಲ್ದಾಣದಿಂದ ಆಟೋದಲ್ಲಿ ನಾನು ಮನೆಯಿಂದ ಬಂದ ದಿನವೇ ಸಂಜೆ ಯಾವುದೋ ನನ್ನ ತಂದೆಗೆ, ಅಪ್ಪ ನನ್ನನ್ನು ಹುಡುಕಬೇಡಿ, ನಾನು ಮನೆ ಬಿಟ್ಟು ಬಂದಿರುತ್ತೇನೆ ಎಂದು ಹೇಳಿದೆ. ತದನಂತರ ನರಸೀಪುರದಲ್ಲಿ ಬೇರೆ ಯಾರದೋ ಫೋನನ್ನು ಪಡೆದುಕೊಂಡು ವಿಜಯನಿಗೆ ಫೋನ್ ಮಾಡಿ ನಾನು ಮನೆಯನ್ನು ಬಿಟ್ಟು ಬಂದಿರುತ್ತೇನೆ, ನನ್ನನ್ನು ಬಂದು ಕರೆದುಕೊಂಡು ಹೋಗು ಎಂದು ಹೇಳಿದನು. ಅದೇ ದಿನ ರಾತ್ರಿ ಸದರಿ ವಿಜಯ್ ನರಸೀಪುರಕ್ಕೆ ಬಂದು ನನ್ನನ್ನು ಒಂದು ಬೈಕ್ನಲ್ಲಿ ಚಿಕ್ಕಬ್ಯಾಗನಹಳ್ಳಿ ಗ್ರಾಮಕ್ಕೆ ಅಲ್ಲಿ ವಿಜಯನ ಸಂಬಂಧಿಕರ ಮನೆಯಲ್ಲಿ ನಾನು ಮತ್ತು ವಿಜಯ್ ಆ ದಿನ ಒಂದು ಹಿಡಿದುಕೊಂಡರು. ನನ್ನ ಮತ್ತು ವಿಜಯನ ನಡುವೆ ದೈಹಿಕ ಸಂಪರ್ಕವಾಗಿರುತ್ತದೆ. 6ನೇ ದಿನ ನನ್ನ ತಂದೆ ನಾನು ಕಾಣೆಯಾಗಿ ಗ್ರಾಮಾಂತರ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ದಿನಾಂಕ 20/8/2021 ನನ್ನ ತಂದೆ ವಿಜಯನ ಸ್ನೇಹಿತರೊಬ್ಬರಿಗೆ ಪಾರ್ಟ್ನಲ್ಲಿ ಪಂಚಾಯಿತಿ ಮಾಡುವುದಾಗಿ ಹೇಳಿ ನಮಗೆ ಬರಲು ತಿಳಿಸಿದ್ದರು. ಅದರಂತೆ ನಾವು ದಿನಾಂಕ 20/8/2021 ಸುಮಾರು 1 ರಿಂದ 2 ಗಂಟೆಗೆ ಪಾರ್ಟಿಗೆ ನನ್ನನ್ನು ವಿಜಯ್ ಕಡೆಯವನೊಬ್ಬ ರಮೇಶ್ ಎಂಬುವವರು ಕರೆದುಕೊಂಡು ಹೋದರು. ಅಲ್ಲಿಂದ ರಮೇಶ್ ಅವರು ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಪೊಲೀಸರು ನನ್ನನ್ನು ವಿಚಾರಿಸಿ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ನಾನು ಪೊಲೀಸರಿಗೆ ನಾನೇ ಮನೆಯನ್ನು ಬಿಟ್ಟುಕೊಂಡಿರುತ್ತೇನೆ ಎಂದು ತಿಳಿಸಿರುತ್ತೇನೆ. ಆ ನಂತರ ಸದರಿ ಠಾಣೆಗೆ ವಿಜಯನು ಸಹ ಬಂದಿದೆ. ಪೊಲೀಸರು ನನ್ನನ್ನು ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಪರೀಕ್ಷೆಯನ್ನು ಮಾಡಿಸುತ್ತಾರೆ. ಸಾಕ್ಷಿಯ ಇದರಲ್ಲಿ 363 ಬರೋದೇ ಇಲ್ಲ. ಒಂದು ಡಿಸಿಷನ್ ಇದೆ. 363 ಬರೋದಿಲ್ಲ.
ವರದರಾಜನ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ತಮಿಳುನಾಡು. ಅಲ್ಲ, ಅದ ಓಲ್ಡೆಸ್ಟ್ ಆನ್ ದಿ ಪಾಯಿಂಟ್ 1965 SL. Aito, Varadarajan is on the point, 363 bitpudi. Whether the girl loves the boy or the boy loves the girl was the issue. But the question is about the POXO.
The medical examination page is page 31. Page 32. Yes. Last line. On genital, physical, and genital examination of body is also. Where is the above mentioned identification parts? I am of the opinion that so and so is used for sexual act and the specimens
Collected,
are
sent for FSL examination. Yes. Yes, please.
After detailed history, the examination and FSL report, the number one.
Yes.
Sign was not detected. In the article number 1, 2, 3, 6, 7, 8, and 9. Convert was of or 15 also 14 years.
Yes.
Next 42. Again,
Yes.
same it is repeated.
Yes, please.
After 42. 42.
Yes.
Analysis. Observations and tests detected. The suspected styles will observe for their
All right. Why are not detected is opinion.
opinion. Seminar style was not detected.
Yes. Yes.
Convert was not detected.
Why are you wasting time when she herself admits that there was a physical relationship? Hyman is absent. Doctor is also opinion that she is used to sexual act. She herself before the court under 164 says that there was a physical relationship. Completes the section 3 of the POX Act. That's all. Yes, Barkoli. Heard. Sri Chandrasekhar, Learned Counsel for Petitioner and Learned HGP. Present petition is filed under section 439. ಇನ್ನೊಂದಿದೆ ಯೂಶುವಲ್ ಆಗಿ ಕೋರ್ಟ್ನವ್ರು ಮಾಡ್ತಿರ್ತಕ್ಕಂಥದ್ದು ನಮ್ಗೆ ಅನುಕೂಲ ಅನ್ನೋದಾದ್ರೆ ನೋಡಿ ಒಂದ್ ಮೆಮೊ ಕೊಡಿ ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಆದ್ಮೇಲೆ ಆ ವಿಕ್ಟಿಮ್ಗಳದು ಅವಳೇನು ಹೇಳಿಲ್ಲ ಅಂತಂದ್ರೆ ಆವತ್ತಿನ ದಿವಸ ರಿಪೀಟ್ ಮಾಡ್ಬೋದು ಬೇಲ್ ಪೆಟಿಷನ್ ಲಿಬರ್ಟಿ ಇರುತ್ತೆ. ಈಗ ನೀಡ್ ನಾಟ್ ಟ್ರಸ್ಟ್ ಅಂದ್ಬಿಟ್ಟು ಮೆಮೊ ಕೊಡಿ ಅದನ್ನ ಮಾಡಬಹುದಾ ನೋಡಿ. 230 ತಗೋತೀನಿ. 230. ಆಲ್ ರೈಟ್ ಇವಾಗ ಕೊಟ್ಬಿಡಿ ನನ್ನ ಮೆಮೊ ಫೈಲ್ ಆಫ್ಟರ್ ಹಿಯರಿಂಗ್ ಶ್ರೀ ಚಂದ್ರಶೇಖರ್ ಫಾರ್ ಸಮ್ ಟೈಮ್. Memo file, memo reads as under the memo. Question is dismissed as withdrawn with liberty as paid for. Yes, Kiran.
Milad, I am for the petitioner, Milad.
Yes.
Offense is 419 and 420, Milad.
Yes, dispensation and all. What to be looked into? Or how should we dispense with certified copy?
Milad, I have certified copy in 6 connected matter, Milad. Same offense,
right.
same FIR.
Barkoli, 67. Since the certified copy is filed in 1854 criminal petition 1854 of 2022, IA 1 of 2022 is allowed. Release this matter for admission on 6/4. Yes. Wait, mister. Why are you? 68. Yes, what is this IA? De facto complainant, office objections, application filed by the de facto complainants. ಅವ್ರು ಯಾರು ನೋಡಿ? Yes, ಅವ್ರ ಕಾಪಿ ಎಲ್ಲ ಕೊಡಿ. Land counsel for the de facto complaint submits that he would be complying with the office objections today itself. Release this matter on 6/4. 6/4. Yes, ಅಲ್ಲಿ ಕೊಡಿ. ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು ಅವ್ರಿಗೆ? ಅವ್ರ ಕಾಪಿ ಕೊಡ್ರಿ. ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕ್ರಿ ಕಾಪಿನ, ಇವ್ರಿಗಲ್ಲ. ಇಲ್ಲೇನಿದೆ ನೋಡ್ಕೊಳ್ರಿ, ಅದೆಲ್ಲ ನಾನು ಮಾಡಕ್ ಹೇಳ್ರಿ, ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ.
ಒಂದು ಸಬ್ಮಿಷನ್ ಮೇಲೆ 1739 ಅಲ್ಲಿ
42 ಮೆಮೋ ಫೈಲ್. ವೇಟ್ ಅಮ್ಮ, ಒಂದೊಂದ್ ಮಾಡ್ತಾರ. ಇದೇನಮ್ಮ ಮೆಮೋ ಕ್ವೆಶ್ಚನ್ ಇಸ್ ಡಿಸ್ಮಿಸ್ಡ್ ಆಸ್ ವಿಡ್ರಾನ್. ಬಟ್ ಏನಾರು ಕೇಳಿದಾರ? ಆಲ್ ರೈಟ್. ಎಸ್ ಹೇಳಿಮ್ಮ. ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವ್ದಮ್ಮ? On behalf of Sri C.H. Hanmantraya, time period stating that Sri Hanmantraya is not well, release this matter. ಯಾವತ್ ಬೇಕಮ್ಮ? 12/4.
ಒಂದು ಸಬ್ಮಿಷನ್ ಮೇಲೆ
ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್? 16. ಹರೀಶ್ ಕುಮಾರ್. 482 ಇದೆಲ್ಲ ಹೇಳಿ ಏನಿದೆ ಅಂತ. ಲೆಟ್ ಅಸ್ ಸೀ ದಿ. ಸರಿ, ಬೆಳಗ್ಗೆ ಇರ್ಲಿಲ್ವಲ್ಲ ನೀವು ಕೇಸ್ ಕರೆದಾಗ? ಈಗ ಹೇಳಿ. ನೋ ಮಿಸ್ಟರ್, ಇಟ್ಸ್ ಓನ್ಲಿ ಕ್ವಶನ್ ಆಫ್ ಇಶ್ಯೂ ಆಫ್ ಸಮನ್ಸ್. ಆ ಇಶ್ಯೂ ಆಫ್ ಸಮನ್ಸ್ಗೆಲ್ಲ 482 ಹಾಕೊಂಡ್ರೆ ಹೆಂಗಾಗುತ್ತೆ? ಆಲ್ ರೈಟ್. At request of counsel for petitioner, release this matter on 4/4. Then argue in the afternoon. If you have everything at if you are arguing by 4/4, well and good. Yes, that's all. ಆಯ್ತು ಇವ್ರೆ, ಅದಕ್ಕೆ 4ನೇ ತಾರೀಕು ಬನ್ನಿ. Yes.
ಒಂದು ಸಬ್ಮಿಷನ್ ಮೇಲೆ
Family court commences at 11 o'clock. You come by 10:30.
ಒಂದು ಸಬ್ಮಿಷನ್ ಮೇಲೆ 1854 ಅಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಗೆ ಅಂತ
ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳ್ರಿ.
67 ಮೇಲೆ 67.
ಹೇಳಿ.
67 ಅಲ್ಲಿ 1854 ಇಟ್ ವಾಸ್ ಲಿಸ್ಟೆಡ್ ಫಾರ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಫ್ ಎನಿ ಅಂತ ಆಗಿತ್ತು ಸುಮ್ಮನೆ ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ.
ಆಯ್ತ್ರಿ, 64 ಹಾಕಿದ್ದೀನಲ್ಲ, ಅದ್ರ ಜೊತೆಗೇನೆ ಅಷ್ಟೇ. ಇನ್ನು ದಿಸ್ ಒನ್, ಸೊ ಇಟ್ ಇಸ್. ಯಾವುದು? 66 ಮಾಡ್ತಾರೆ ಬಿಡಿ. ಎಸ್, ಆಲ್ ರೈಟ್.
ನಾನು ಫೋಟೋ ಪ್ರಿಂಟ್ ಮಾಡೋಣ.
ಅದು ಮಾಡ್ಬೇಕಾ? Refreshment. End ಅಂದ್ಬಿಟ್ಟು ಅಷ್ಟೇ. ಅದು ಯಾವ್ದೋ ಹಳೆ ತೋರಿಸ್ತಾ ಇದೆ.
ಲಾಗಿನ್ ಆಗಿಲ್ಲ.
ಲಾಸ್ಟ್ ಸೀನ್ ಇದೆಯಲ್ಲ, ಅದ್ರಲ್ಲಿ ಕೂತಿದ್ದಾರೆ ನೋಡಿ, ನಿಂತಿದ್ದಾರೆ. Yes, please. Serial number 10. Memo filed. Memo reads as under memo. Petition is dismissed as withdrawn with liberty as prayed for. Yes.
Second respondent has complained. As filed. Complaint against the petitioner and 324 financial finance.
Correct.
The allegation is that the complaint is the second respondent is practicing advocate. And he is prosecuting the case of the one Govinda Swami with respect to land clearing survey number 25/1.
Yes.
On 9/7/2021 at around 11 a.m. the said Govinda Swami had come to his office and he informed that the petitioner and his brothers are illegal construction efforts over the property. In this regard, the second respondent as well as the Govinda Swami went to the office to lodge a complaint.
Correct.
Lordship. Kindly see Lordship, the in page number 30. Remember, in page number 30, Lordship. ಸ್ಥಳಕ್ಕೆ ಬರುವಂತೆ ಇಲ್ಲಿ ವಾಪಸ್ ಮನೆಗೆ ಬಂದಿದ್ದೀರಿ. This is the statement of the Govinda Swami. In page number 30. And in the complaint, in page number complaint, in complaint 13, challenge. In 13, ಚಿಕ್ಕಪರಸ್ಪರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 25/1 ಬಳಿ ನನ್ನ ಕೃಷಿ ತಾಳದೊಂದಿಗೆ ಸುಮಾರು 12 ಗಂಟೆಗೆ ಹೋದಾಗ BM ನಾರಾಯಣ ಸೋನ್ಸೋ. And in the statement he said that after information he had been to his home, but in the complaint he said in a different aspect. And Lordship, in page number, Lordship, in page number 39, Lordship. He said Govinda Swami has lodged the complaint under this petition and others on the same incident, on the same day. See, the second respondent has filed file number 189, the petitioner has filed 190, the Govinda Swami, who is the client of the present respondent number 2, he filed 191 crime number. This is 2 FIRs on the same incident has been lodged. At my place, file number 190, page number 34, the present petitioner, the present respondent number 2, as well as the said Govinda Swami accused, the both are accused in page number 35. The crime number is 190, page number 34, Lordship, 34. It is not with the petitioner number 1 AD. And accused number 1 is the Govinda Raju. Accused number 4 is the Kudusananelli Venkatesh. The Kudusananelli Venkatesh has filed a separate case. The accused number 1 is filed a separate case against the petitioner. I grievance is the Lordship. Two FIRs have been lodged against the petitioner. And the important aspect, Lordship, in page number, Lordship can see 32. Why the 323 has been invoked? Kindly see the doctor's period certificate not valid for medical legal purpose. In page number 32 as well as 33, Lordship. 32, 33. It has been, they say the 323 has been invoked.
What is the charge sheet filed for which crime number?
189 has been filed.
No, here before the court in crime number 189.
Yes, Lordship.
Charge sheet is filed in respect of which crime number?
189 only.
Yes. Now that will be decided.
So that means that 2 FIRs has been lodged against the present petitioner. In the mind frame, the 2 petitions, the 2 against, there are 2 complaints.
Two different incidents, therefore 2 FIRs. Yes. There
is no such 2 incidents, Lordship.
But you go and file an application for discharge. Summons issue ಮಾಡಿದ 482 ಬಂದ್ರೆ ಏನ್ ಮಾಡೋದ್ರಿ? Yes, ಬರ್ಕೊಳ್ಳಿ.
There is no such 323.
What is the order that has been passed by the magistrate now?
Summons has been issued.
Go there, make a submission.
2 FIRs on the same incident, Lordship.
That is for the police to decide whether it's a separate incident or separate charge sheet is filed. Now the charge sheet is filed with respect to one case, not two cases. That's it.
The charge sheet has been filed one case, but the thing is that the both persons, the advocate as well as the party has been BPM judges together, and they came to the spot together, and one FIR has to be lodged. But instead of the one FIR, there is two FIRs. That is a my grievance.
That is now before the court is issuing summons in respect of a crime where the charge sheet has been filed. That's all. Verbally heard. Counsel for the petitioner. Question under section 482 CRPC with the following prayer. First, next para. Brief facts of the case are as under. A complaint came to be filed by the second respondent herein on 9/7/2021, stating that he is engaged in respect of a civil suit of one Govinda Bhetta, Govinda Swami in respect of a civil dispute. First, on 9/7/2021 at about 11 a.m., said Govinda Swami came to his office and informed him that D.M. Narayana and his son and his children and brothers have illegally erected hollow block shed whereby Govinda Swami is unable to reach his land. First, therefore, they went to the office of the assistant executive engineer in Kyarpuram. First, assistant executive engineer by name Naveen visited the spot in Priyadarshini layout in survey number 25/1 at about 12 noon. At that juncture, the second respondent also accompanied the Govinda Swami, and Narayana and his brothers addressed the second respondent and abused him in a filthy language and also gave a life threat. They also threatened him that they would file SC/ST case against the lawyer, against the second respondent, and also assaulted him with clubs and hands. They further gave life threat. First, based on the said complaint, Kyarpura police registered a case in crime number 189 of 2021. First, for the offences punishable under section 323, 324, 504, 506, that is section 34 IPC. First, police after thorough investigation filed charge sheet against the petitioners herein in respect of crime number 189 of 2021. First, next para. Learned magistrate took cognizance of the aforesaid offences and issued summons to the petitioners herein. It is that proceedings which are subject matter of the present petition. First, Lord Counsel for the petitioner contended that in respect of the very same incident, Govinda Swami has also lodged a complaint, and in respect of only one incident, 2 complaints have been filed, which has resulted in jeopardizing the rights of the petitioner and thus sought for washing of the further proceedings. First, he also contended that earlier to the filing in respect of the very same incident, on 9/7/2021, petitioner by name BN, one of the petitioners by name Narayan, DM Narayan has also approached the police, Kerpuram police, and they have also lodged a complaint which is registered in crime number 190 of 2021 for the offences punishable under section 307, 504, that is section 149 IPC, wherein the second respondent herein, who is the complainant, is also one of the accused, and he has been named as fourth accused in the FIR. First, he further contended that Govinda Raju is the first accused, who is none other than the Govinda Swami. First, he further contended that registering the two cases against the petitioners herein in respect of only one incident is incorrect and illegal. First, he also contended that the wound certificate issued by Shankar Nursing Home and Diagnostic Laboratory in respect of the second respondent clearly mentions that it is not for the purpose of medico-legal cases, and therefore the investigation agency has filed a false charge sheet and sought for washing off further proceedings. First, next para. It is pertinent to per contra, next para. A copy of the petition is given to the learned HCGP. ಮೇಲ್ಗಡೆ HCGP takes ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. HCGP take notice. ನಿಮ್ ಕಾಪಿ ಬಂದಿದೆಯಾ ಅವ್ರೆ? ಮತ್ತೆ ಕೊಡಿ, ಒಂದು ಕಾಪಿ ಕೊಡಿ. ಅದು ಈಗ ಮೂರ್ ಕಡೆ ಇರುತ್ತೆ, ನೀವು ಎಲ್ಲ ಯಾರು ಕೊಟ್ಟಿರ್ತಾರೆ ನೋಡ್ಕೋಬೇಕು ನೀವು. Sorry. HCGP opposes the bail petition. HCGP opposes the petition prayer. First, next para. Having heard the petitioner, and perusal the record, this court is of the considered opinion that all these grievances of the petitioner must be urged before the learned judicial magistrate, learned trial magistrate in the form of an application seeking discharge. First, however, it is too premature for this court to express any opinion on the merits of the matter, as what has been ordered by the learned trial magistrate is only summoning the petitioners to appear before the court after taking cognizance of the offences mentioned in the charge sheet in respect of crime number 189 of 2021. First, it is also pertinent to note that police have not filed any charge sheet in respect of the very same incident where the Govinda Swami is the complainant, which is registered in crime number 190 of 2021. 191 of 2021. First, therefore, reserving the liberty for the petitioner to file appropriate application before the jurisdictional trial magistrate, petition stands disposed of. ನಾನು ಆಗ್ಲೇ ಹೇಳಿದೆ ಅವ್ರಿಗೆ. Just a serial number. Time and case called twice. Petitioner counsel absent. Sufficient opportunity is granted to cure the objections. There is no representation on behalf of the petitioner. The objections are not cured. First, next para. In the interest of justice, 2 days time is granted to cure the objections. If not cured, the matter be listed for dismissal on 8/4. Yes, please. Yes. ಹೇಳಿ. Yes, please. Hmm. 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 ಹೋಗಿದ್ದಾನೆ ಮತ್ತೆ ಏನ್ ಮಾಡ್ತಾರೆ ಆಗಲ್ಲ ಅಂದ್ರೆ ಇದೆಲ್ಲಿ ಅದು ಬರ್ತಾ ಇಲ್ವಲ್ಲ ಯಾವ ಮೋಡ್ಗಾರು ಹೋಗ್ಕೊಳ್ಳಿ ಈ ಕಾಲಿನ್ it is the situation ಅದು it gives a wrong signal.
Inclined to ಅದಕ್ಕೇನೆ ಸಪ್ರೇಟ್ ಆಗ್ಬೇಕಾಗುತ್ತೆ ಕರಿತೀನಿ
ಈಗ ರಿಕವರಿ ಎಷ್ಟಿದೆ ನಿಮ್ಮಿಂದ? ಮತ್ತೆ ಎಲ್ಲಿಂದ ಬಂತು ನಿಮ್ಗೆ? wait sir, let him say. Your friend is arguing the matter, let him say. What is your avocation, sir? You are the tenant under the deceased. You are a tenant. They knew that so much of money was with you. All right, what is ನೀವು ಏನ್ ಕೆಲಸ ಮಾಡ್ತೀರಾ ಅದ ಹೇಳಿ, ಅವ್ರು ಅಲ್ದೇ ಇದ್ರೆ ಬೇಡ. Why this matter before this court? ರಾಯಚೂರ್ ಯಾಕೆ? Why this matter before this court? ಅಲ್ಲ ಇವ್ರೆ ಕರೆಕ್ಟು, ಅವ್ನು ರಾಯಚೂರ್ನಲ್ಲಿ ಹೋಗಿ ಎಂಪ್ಲಾಯಿನಲ್ಲಿ ಏನ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಇದ್ದ? ಮತ್ತೆ ಹಂಗಾದ್ಮೇಲೆ 19.5 ಲಕ್ಷ ರೂಪಾಯಿ ಒಬ್ಬ ಮನುಷ್ಯನ ಹತ್ರ ಸಿಗುತ್ತೆ ಕ್ಯಾಶ್ ನೋಡ್ರೆ ಹಾಗೆ ಅವನು ಈಸ್ ದಿ ಪ್ರೆಸಿಡೆಂಟ್ ಆಫ್ ರಾಯಚೂರ್ ಅಲ್ವಾ? ಸೋನಿಯಾ ಗಾಂಧಿ ಕಾಲೋನಿ, ಮಾನ್ವಿ ಟೌನು, ರಾಯಚೂರ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್. ವಾಟ್ ವಾಸ್ ದಿ ನೆಸೆಸಿಟಿ ಫಾರ್ ಹಿಮ್ ಟು ಕಮ್ ಓವರ್ ಆಲ್ ದಿ ವೇ? ಅಡಗೋಡಿ ಪೊಲೀಸ್ ಲಿಮಿಟ್ಸ್ ಒಳಗಡೆ ಯಾಕೆ ಬರ್ತಾರ ಅವರು? ಹೊಡೆದು ಅಲ್ಲಿ ದುಡ್ಡು ತಗೊಂಡು ಹೊಟ್ಟೋಗ್ಬಿಟ್ಟಿದ್ದಾನೆ, ಚಿನ್ನದ ಸರ ಎಲ್ಲ ತೆಗೆದುಕೊಂಡು ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಬಂಗಾರ 50 ಗ್ರಾಮದ ಬ್ರಾಸ್ಲೆಟ್ ಎಲ್ಲ ತೆಗೆದುಕೊಂಡು ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಕತಿನ್ ಚೈನ್ 30 ಗ್ರಾಮು. ಅಂಡ್ ಹಿ ವಾಸ್ ಅರೆಸ್ಟೆಡ್ ನಿಯರ್ ದಿ ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ ಅಲ್ವಾ? ಅದಕ್ಕೆ ಕೇಳಿದ್ದು ವಾಟ್ ಇಸ್ ದಿಸ್ ಅವಕೇಶನ್ ಅಂತ. ಎಸ್ ಪ್ಲೀಸ್, not a case for grant. Yes, please. Third Sri Vishwanath and learned HCGP. Present petition is filed under section 439 CRPC with the following prayer. First, next para. Brief facts of the case are as under. Appayanna son of late Gullappa, lodged a complaint with Kadagodi PS, Whitefield subdivision on 12/8/2020, which was registered in crime number 161 of 2020 for the offence mentioned under section 302 IPC. In the complaint, it is contended that he had been to, in the complaint it is contended a copy of the complaint ಅಲ್ಲಿ ಅದೇ ಹೇಳ್ತೇನೆ. Typed copy of the complaint ನೀವು ಹೋದ್ರಲ್ಲ page ಹೇಳಿ. On 12/8/2020, at about 10:30 a.m., he had gone out of the house for the purpose of paying the electricity bill on his motorcycle. First, after paying the electricity charges, he had been to Ambedkar Gutte and had a conversation with his friends Marappa, Muddumadaya for about 45 minutes. First, at about 1:15, he returned to the house. First, the front door of the house was closed and he pushed the door and went inside the house. First, he found his wife lying on the floor and she was not responding. First, he observed that there was a blood injury in the neck and his wife was no more. The television was put on in the house. First, immediately he informed the incident to his children and went inside the bedroom. First, he found that the iron trunk was kept open and somebody had thieved the cash which was kept in the iron trunk to the tune of 45.5 lakhs and also the neck chain worth 30 grams and 2 finger rings weighing, weighing 8 grams and about 50 grams of gold bracelet, bank checks and 6,000 rupees loose coins were missing. First, based on the complaint, police registered the case against the unknown persons at the inception and after thorough investigation filed the charge sheet against the petitioner herein. Petitioner and others. First, petitioner is the third accused as per the charge sheet filed by the police. First, during the course of investigation, petitioner has been apprehended and based on the voluntary statement given by him, investigation agency is able to recover 19 lakhs. Yes to 19 lakhs. PP 1818. 19 lakhs 18,337 rupees from the custody of the present petitioner. First, admittedly, next para. In the meantime, the effort made by the petitioner to get him enlarged on bail is turned down by the learned session judge in SC number 30/2021 by order dated 24 June 2021. First, thereafter petitioner is before this court seeking grant of bail. First, reiterating the next para, reiterating the grounds set in the bail petition, Sri Vishwanath vehemently contended that petitioner is nowhere connected with the incident and he has been falsely implicated in the case. First, he further contended that the alleged recovery by the investigation agency has got nothing to do with the case and petitioner is resident of Raichur district, Manvi Taluk, and therefore at no stretch of imagination, present petitioner is involved in the incident and sought for grant of bail. Next para, per contra, learned HGP opposes the bail petition on the ground that huge sum of cash to the tune of 19,18,313 was recovered by the investigation agency based on the voluntary statement given by the accused. First, accused is not gainfully employed, so as to have such a huge sum of money in his house, and therefore, prima facie, the investigation agency is able to establish the nexus between the incident and the accused petitioner and sought for dismissal of the bail petition. First, next para. Having regard to any of the rival contentions, this court meticulously perused the matter on record. First, next para. Admittedly, a case came to be filed against the unknown persons. First, the complainant's wife is murdered, and thereafter the valuables kept in the house have been robbed away by some unknown persons as per the complaint governments. First, after registering the case, police were able to apprehend the present petitioner and others. First, during the course of investigation, based on the voluntary statement given by the present petitioner, investigation agency is able to recover cash to the tune of rupees 19 lakhs so and so, 18,313 from the custody of the accused. First, the accused is unable to explain how he got this money. First, anyway, it is for the district trial judge to consider all these aspects of the matter on merits during the trial. First, it is too premature for this court to express any opinion on the merits of the matter, as the same may prejudice the case of the parties during the trial, one way or the other. First, next para, suffice to say that since the huge cash has been recovered, which is the amount that has been robbed from the house of the petitioner, prima facie, the prosecution investigation agency is able to establish the nexus between the crime and the present petitioner. First, these aspects of the matter, when taken into consideration cumulatively, this court is of the considered opinion that material on the grounds urged on behalf of the petitioner are hardly sufficient to consider his request for grant of bail by resorting to the special powers vested in this court under section 439 CRPC. Accordingly, following order, bail petition rejected. And regard to the fact that accused is in custody, trial court is directed to expedite the trial. Noted. Yes, please. Yes, please. Sorry? Kodi. What is the role assigned to the present petitioner? Please say what is the role assigned. Don't say same as accused number 5. You read from the material. Page number. Now kindly read para 6 of the coordinate bench order. ಕಟ್ಟಿಯಾಗ ಓದಿ. ಅರ್ಥ ಆಯ್ತಲ್ವಾ? ಪ್ಯಾರಿಟಿ ಬರುತ್ತಾ? 4 ಜನ ಅಂತ ಕಂಪ್ಲೇಂಟ್, ಇವ್ರನ್ನ ನಂತರ ಸೇರಿಸಿರ್ತಕ್ಕಂಥದ್ದು ಅಂತ. ಮೆಟೀರಿಯಲ್ ಆನ್ ರೆಕಾರ್ಡ್ ಇರೋದನ್ನೇ 4 ಜನ ಹೊಡೆದಿದ್ದು ಅಂತ. ರಿಕವರಿನೂ ಇದೆ ನಿಮ್ಮಿಂದ, ಅವರಿಂದ ರಿಕವರಿ ಇಲ್ಲ. Yes. No, please. Don't say something which is incorrect. Don't say something which is incorrect. You said that my accused stands on the same footing that of the person who accused number 5 who has been granted bail. It is false submission. Yes, ಬರ್ಕೊಳ್ಳಿ. ರಿಟರ್ನ್ ಮಾಡಿ ಮತ್ತೆ. Memo file, memo reads as under, the memo petition is dismissed as withdrawn. ಸುಯಾಗ್ ಅವರೇ, ಪ್ಯಾರಿಟಿಗೆ ಬರುವಾಗ ಈ ಕೋರ್ಟ್ ನೊಳಗಡೆಗೆ ಯು ಕಾಂಟ್ ಟೇಕ್ ದಿ ಥಿಂಗ್ಸ್ ಫಾರ್ ಗ್ರಾಂಟೆಡ್. ದಟ್ಸ್ ಆಲ್. ದಿಸ್ ಕೋರ್ಟ್ ಈಸ್ ಆಫ್ ನಾಟ್ ದಟ್ ನೇಚರ್. ಅವ್ರಿಗೆ ಯಾರಿಗೋ ಕೊಟ್ಟಿದ್ದಾರೆ ನೀವು ಕೊಡಿ, ಇನ್ಯಾರೋ ಕೊಟ್ಟಿದ್ದಾರೆ ನೀವು ಕೊಡಿ. ಸಾರಿ, ಪ್ಲೀಸ್ ಮೇಕ್ ಔಟ್ ಎ ಕೇಸ್. Parity is an additional ground. You see, if a person is granted bail, your case and his case must be practically akin to each other. It is not so in this case. And if I had accepted your submission and granted bail, what would it have? Would have resulted in injustice. ಎಷ್ಟೋ ಸಂದರ್ಭದಲ್ಲಿ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅವ್ರಿಗೆ ಅದನ್ನ ನೋಡಿ ಕೇಳಿ ಅದನ್ನೆಲ್ಲ ತಿಳ್ಕೊಂಡು ಮಾಡೋಷ್ಟು ವ್ಯವಧಾನ ಇರುವುದಿಲ್ಲ. I have told the HGP to devise a mechanism in the HGP office that once a crime, particular crime, an order comes, we have in our records, granted, not granted. It is their duty to take out that copy and then make a submission before the court that, sir, on parity this man is not entitled. On parity is entitled. ಮೊದಲನೇದು ಹೇಳ್ಬೇಕು, ಎರಡನೇದು ಹೇಳದೇ ಇದ್ರು ಪರವಾಗಿಲ್ಲ, ನಾವು ನೋಡ್ಕೋತೀವಿ. ಅವ್ರೇನು ಫೇರ್ ಆಗೇನು ಅದನ್ನ ಹೇಳಿ ಅದನ್ನೇನು ಕೊಡ್ಬೇಕಾದ ಕೇಸಲ್ಲಿ ಹೇಳ್ಬೇಕಾಗಿಲ್ಲ. ಎಲ್ಲಿ ಕೊಡಬಾರ್ದು ಅಲ್ಲಿ ಎಚ್ಚರ ಮಾಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕಲ್ಲ ಅವ್ರು. Their rush of work, so many things happen, the matters are being listed somewhere here, there and all these things. It will have a serious impact. ತಾವು ಕೊಟ್ರಿ ನಾನು ನೋಡ್ದೆ ಒಂದೇ ವ್ಯವಧಾನ. See, the problem is no court will refuse on the ground of parity usually. Follow me. Long way to go. You are an youngster. You are an youngster. Long way to go. Don't take it offensively. This is a word of piece of advice from the court. Once you lose your credibility, ಬರ್ತಾನಪ್ಪ ಹುಡುಗ ಸುಳ್ಳಪ್ಪಳ್ಳ ಹೇಳ್ಬಿಟ್ಟು ತೊಗೊಂಡೋಗ್ಬಿಡ್ತಾನೆ ಆಡ್ರು ಅಂತ ಒಂದ್ಸರ್ತಿ ನಮ್ಮ ಮನ್ಸಿಗೆ ಬಂದ್ಬಿಟ್ರೆ, ಅಲ್ಲ ಬಂದಿಲ್ಲ ಈಗ, ಬಂದ್ಬಿಟ್ರೆ it will have an impact. We also meet in the tea hall. We also meet elsewhere. Be careful about that boy. He misleads the courts ಅಂತ ನಾವು ಹೇಳ್ತೀವಿ. ನಾನು ಹೇಳ್ದಲ್ನೇ ಇರ್ಬೋದು, ಡಿಸ್ಕಷನ್ ಬರುತ್ತಲ್ಲ. ಸೊ ಕ್ರೆಡಿಬಿಲಿಟಿ ಕಳ್ಕೋಬೇಕು. ಆಯ್ತು, ಕೇಸ್ ಇದೆ ಸರ್, ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ, ಇವನ್ಗೂ ಕೊಡ್ಬೋದ ನೋಡಿ, ಅದೇ ಪ್ರಶ್ನೆ. All right. Yes, please. Yes, mister. Yes, please. Yes, please. Yes, he has been a life convict. Yes, please. Yes, please. Yes, please. Classic example of reformatory theory being failed. Right? Classic example of reformatory theory, failure of reformatory theory. Person has been already convicted. ಹೋಗ್ಲಿ ಪಾಪ ಅಂತ ಕರ್ಕೊಂಬಂದ್ ಕೆಲ್ಸಕ್ಕೆ ತುಡಿಯಕ್ಕೆ ಇಟ್ಕೊಂಡ್ರೆ ಹೆಂಡತಿಗೆ ಮಚ್ಚಲ್ ತಲೆ ಹೊಡೆದ್ಬಿಟ್ಟು ಸಾಯಿಸ್ಬಿಟ್ಟು ಹೊಟ್ಟೋಗ್ಬಿಡ್ತಾನೆ ಬರೇ 8,000 ರೂಪಾಯಿಗೆ. ಓನ್ಲಿ ಫಾರ್ 8,000 rupees. ಈ ನಂಬ್ಕೋಸ್ತಾರಲ್ಲ, ನಾನು ಹೆಣ್ಮಕ್ಳಿಗೂ ನೋಡಿ ಗೊತ್ತಾಗೋದಿಲ್ಲ, ಇಂಥವ್ರಿಗೆ ಮೂರ್ ಮದ್ವೆನೂ ಆಗತ್ತೆ. ಹೌದು, 3ನೇ ಮದ್ವೆನೆ, ನಾನು ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. ಎಸ್, ನಾಟ್ ಎ ಕೇಸ್ ಫಾರ್ ಗ್ರಾಂಟಿಂಗ್. ಎಸ್ ಪ್ಲೀಸ್. ಹರ್ಡ್ ಶ್ರೀ, ತಮ್ಮ ಹೆಸರೇನು? ಶರತ್ ಕುಮಾರ್ on behalf of Sri Mohammad Umar Farooq for Aita and learned HCGP. The present petition is under section 439 CRPC with the following prayer. Brief facts of the case are as under. Yashodamma, wife of Rangnathappa, lodged a complaint with Chira police contending that she has a daughter by name Uma Devi. She had a daughter by name Uma Devi, and she had been married to the accused petitioner Ningaraju about 23 years earlier. First, accused had an earlier wife by name Manjula, and he committed her murder, and he was convicted. First, after undergoing the sentence imposed by the court, he returned to the Irigenahalli and was living with the complainant and his daughter, her daughter, First. Thereafter, they shifted to Girnathhalli Navagrama, and there the wife of the deceased was eking out her livelihood by keeping a petty shop and also tying beedi. On 18/10/2020, accused petitioner thieved away rupees 8,000 and went to Hirigenahalli, Costa. In that regard, there was an altercation on 19/10/2020, Costa. The grandson of the complainant informed the complainant stating that in the altercation, accused assaulted the deceased with a machete on her head. Costa. On receipt of information, complainant rushed to the spot and found Uma Devi, the dead body of the Uma Devi in a pool of blood. Costa. Based on the said complaint, Sira police registered a case in crime number 358 of 2020 for the offence punishable under section 302 IPC on 19/10/2020 and have investigated the matter and filed the charge sheet against the accused for the offence under section 302 IPC on 8/1/2021. Costa. Accused was arrested during the course of investigation and he has been sent to judicial custody. Attempt made by him seeking grant of bail is turned down by the Additional District Judge Tumkuru by order dated 18 September 2021 in series number 1008 of 2021. Thereafter, the petitioner is before this court. Joint counsel for the petitioner reiterating the grounds urged in the bail petition, contended that the petitioner is innocent of the offences alleged against him and he has been falsely implicated in the case and sought for grant of bail. Per control and HCP contended that the petitioner is a known criminal and he has married for the third time and in order to meet the expenses, he has thieved away sum of rupees 8,000 which was saved by the deceased from her petty shop, and when questioned by the deceased, the accused mercilessly assaulted his own wife with a machete, and the same is seen by the son of the deceased and informed to the grandmother, and these aspects of the matter would clearly show that the petitioner is a known criminal and not entitled for the grant of bail. In view of the rival contentions, this court perused the material on record meticulously. Admittedly, the petitioner was sentenced to undergo life imprisonment, and after completion of the sentence, he had visited Hirigenahalli. Thereafter, the deceased and the petitioner went to Navagrama of Girnathalli, wherein the deceased was having a petty shop, and out of the business in the petty shop and from the BD tying, deceased had saved some more rupees 8,000. Petitioner thieved away the said amount on 18/10/2020. In that regard, on 19/10/2020, there was an altercation between the petitioner and the deceased. In that altercation, the deceased was attacked by the petitioner with a machete by assaulting her on head, resulting in the death of the Uma Devi. The incident is seen by the son of the deceased. The police, after thorough investigation, filed the charge sheet against the petitioner herein for the offence under section 302 IPC. The antecedent of the petitioner comes in the way of this court exercising its discretionary power vested in it under section, its special power vested in it under section 439 IPC, 439 CRPC, even taking note of the age of the petitioner. Suffice to say that the material available on record is hardly sufficient to admit the petitioner on bail. Accordingly, following order is passed, bail petition rejected. Having regard to the fact that petitioner is in custody The trial court is directed to expedite the trial. Chandra Kumar Gowda.
Next week.
Okay.
Filing. File misplace.
ಅಲ್ಲ ಈಗ ಫೈಲ್ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗಿದ್ರೆ ಇಲ್ಲಿ 2 ಕೇಸ್ ಇದೆ. ಅವರು ಹೋದ್ ಸತಿನೂ ಬಂದಿಲ್ಲ, ಅದ್ರ ಹಿಂದಿನ ಸತಿನೂ ಬಂದಿಲ್ಲ. This court recorded on 11/3/2021. The case came to be filed on 12/11/2021. 9/2, 17/2, 11/3, 18/3. All these dates I have granted time. On 21/3, time was granted based on the request made. I'll dismiss it. Otherwise, memo haki ಇನ್ನೊಂದು ಹಾಕೊಳ್ಳಿ, ಯಾವಾಗ ಬೇಕು ಅವಾಗ. ಹೆಂಗಾಗುತ್ತೆ ವಿಶ್ವನಾಥ್ ಅವರು? 21ನೇ ಇಸ್ವಿ ಮ್ಯಾಟರ್ಗಳನ್ನ ನಾವು ಎಷ್ಟು ದಿನ ಅಂತ ಪೆಂಡಿಂಗ್ ಇಡೋದು? On behalf of petitioner Sri Vishwanatha, that council seeks time. Release this matter on 4/4 finally. ಅದು ಅಷ್ಟೇ, ಅವ್ರದೇನೆ ಸೇಮ್ ಆರ್ಡರ್. ಗಿರೀಶ್ ಆರ್ none present on behalf of the petitioner when the case was called. Even after the third round of calling of cases, first same was the situation on 21/3/2022 and on 3/3/2022. First, taking note of the long absence of the counsel for petitioner, issue court notice to the petitioner who is in custody through jail superintendent and release this matter on 12/4. Yes, please. Memo filed, memo reads as under, the memo petition is dismissed as withdrawn. Liberty is Janodama. With liberty as prayed for. Yes. Mohammed Pasha. Case called twice, none present on behalf of the petitioner. This petition is filed in the year 2021. This petition is filed on 29/11/2021, seeking grant of anticipatory bail. First, consistently, counsel for petitioner is absent and is not pursuing the matter. First, one of the conditions for grant of anticipatory bail is that there must be a real and imminent apprehension of arrest. First, since the petition is pending from 2021, since the petition is pending on and from 29/11/2021, and counsel for petitioner has not chosen to argue the matter, this court is of the considered opinion that no real apprehension is made out, and accordingly petition is dismissed for non-prosecution. However, this would not preclude from the petitioner from approaching the court again if there exists a real apprehension of arrest. ಸಾಕು, non-prosecution ಸಾಕಷ್ಟು, ಬೇಕಾದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ, ನಾವ್ಯಾಕೆ. ಕಾರ್ತಿಕ್ ಕುಮಾರ್ ಕೊಡಿ. ಕಾರ್ತಿಕ್ ಕುಮಾರ್ ನೋಡಿ, ಹೇಳಿ. ಇವತ್ತು ಇನ್ನೊಂದು ಲಿಸ್ಟ್ ಕೊಡಕ್ಕೆ ಹೇಳಿ. ಒಂದೇ ಇದೆ 438 ಅಂತ ತೋರಿಸಿ, 4 ನಾನೇ ತೋರಿಸ್ತೀನಿ. What are they doing? ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ, ಒಂದೇ ಇದೆ ಅಂತ ರಾಂಗ್. ಅದು this petition came to be filed on 30th November 2021 under section 439 CRPC. First, thereafter, the petitioner counsel for petitioner is not showing interest in pursuing the matter. First, matter was adjourned on 4/12/2021, 3/3/21. This court noted the absence of the petitioner. Again on 21/3, there was no representation on behalf of the petitioner. First, accused is in custody. Hence, in the interest of justice, issue court notice to the petitioner through jail superintendent and release this matter on 12/4. Yes, please. Yes, please.